Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And, it is a new week. It is a new week, and we have a new week of stuff to do. I hope you guys are ready. I hope you brought your liquor or whatever you need to make things happy for yourself. That doesn't mean a substance, by the way. That just means whatever it is. Your good positive aura. Your positive aura. Your negative aura. Maybe that's what you need. I don't know. I don't know you. But whatever it is, I hope you have that. I hope you have access to that. And I hope you are in a good, comfy place. Today, we are going to we're going to start on a journey. And that journey is going to be going through the documents filed in the appeal. They are the reply briefs for Vic Mignogna against Funimation, Jamie Marchi, Ron Toye, and Monica Rial. That is the plan for today. We are going through Funimation's, but that is the plan for the majority of this week. So, holy cats. Woo! Well, that was fun. I feel like I have another sneeze in there, so that could come out at any time. But I will see what I can do. We are going through Funimation's the reply brief to Funimation's response to Victor Mignogna's appeal today. I believe tomorrow I will probably be going through Jamie Marchi's. Wednesday will be a break. Wednesday, because we're going to have 2 document-heavy days in a row. Wednesday will be a different kind of show. We're going to have Sriracha on. We will be doing Russell Greer and his lawsuit against Taylor Swift, his newest lawsuit against Taylor Swift. And along with that, we will be discussing Russell Greer's arrest as a high schooler for his activity, along with the documents that come with that. So, and then Thursday we will be back to the document pool, and then Friday I'm not positive, but Friday may end up being a Chad Dad show if I get buy-in from the Chad Dads, so to speak. And I've not officially requested them for Friday, but I did say that I wanted to do one in the next week or so, and Friday's typically the day that we do them. So that is what the week looks like. I wanted to lay that out and set clear expectations. After most of the shows this week, including probably tonight, we will be having watch parties on Twitch. And guys, they're a thing of magic and wonder. It's honestly one of my favorite things that they've ever, that anybody, any of these platforms have implemented, is a copyright-free way to, share in a hilarious watching of a movie with people. Tonight, I believe the plan is to watch Way of the Gun, which is Ryan Felipe, Benicio del Toro, and James Caan, along with Sarah Silverman getting punched ruthlessly in the mouth over and over again, which, if you've not seen Way of the Gun, I love the movie. I really do. Also got Taye Diggs in it. Great cast, great acting. Really fantastic story. Don't listen to Drexel. He's bad at it. But yeah, we're gonna be watching that. So come join the Twitch watch party after the show if you're able to. And here's what I do during my day. It's like, oh, I have 10 minutes. Scroll through Amazon Prime looking for stuff like Highlander, the movie. That's on there. Like Beastmaster, like Shoot Fighter 2, starring Bolo Young, like what was it? I think it's Blood Fight, starring the Tabo guy. Why can't I think of his stupid name? You know, Billy Blanks. Billy Blanks. All sorts of great movies that we're gonna be watching. And I might start developing like theme nights. Like this night is going to be an action movie. This night's going to be a horror movie. This night's going to be a teen sex comedy or something. Like that's what we're going to do. There's some weird stuff. There's a ton to watch and lots of fun to have. So, that is something I'm really, really enjoying. And I hope you guys will enjoy and indulge with me on that as we watch good movies, bad movies, and legendarily bad movies. Anyway, so I'll only join you if you watch Highlander the Source. You mean the series? But anyway, so there's that. Now, on Friday, Drexel and I showed a video. It was the Give It To Me Neil music video that is up on my Rekieta Media channel, but I may need some help. YouTube told me that the focus on the sexual content and the, quote, derogatory language in the video, along with the actual title of the video, Give It To Me Neil, are all far too sexual in nature for monetization or for the search and discovery algorithm. That was actually the words that they gave me. It was like a paragraph of how that video could not be not monetized. So I disagree with them for what it's worth. I think that their assessment of it is wrong. I don't think it's sexual at all. But and I don't care about the monetization. I really don't. But it's not going to get like spread on search and discovery, which is YouTube has two different algorithms, one for monetization and one for search and discovery, and they work independently of each other. But sometimes, and this is one of them, they will not be monetized or shared. So I need y'all's help as much as if you like it. If you don't like it, ignore it. That's fine. If you think it's funny, go ahead and share it out so people can enjoy it. I thought it was hilarious. And I think the guy who mixed it up did a really, really good job. So there's that. Was there other stuff? Oh, and I am working on a more serious video for that channel that is completely different. And by working on it, no, I haven't recorded it yet. I'm writing it, which is something I don't normally do. If you see my show, the live show, if you see me doing short videos, I usually do not write them in any tangible way. This one is being written. We're gonna try at least having some sort of framework for it, because it's an in-depth. It's gonna be a part of a series that I'm hoping to release a couple of them before Matsuri, because it's a series that will be relevant to the Matsuri panel on just escapism and storytelling. I know this is completely outside of the law area that you guys are here expecting, but it's completely outside, or it's focused on storytelling and escapism and all of that. And there's going to be a series of those where we use oftentimes movies that we watch during watch parties and stuff like that, or maybe anime or other shows that we watch, or books or whatever, to illustrate an example of escapism and examples of good storytelling techniques that might help people in their own quest to create. That's the point of it. So there you go. That's coming, and when I release it, I'll announce it. But I'm hoping to do some of those. I did. If you caught Anime Matsuri's live stream or the replay the other day, they did confirm that I will be there doing panels. I wasn't sure if I was going to do one panel or multiple panels, and I still technically don't know, but the plural was used. And so I will be at Matsuri, and I will be doing at least one, if not more, panels. So if you guys want to come and fill up a hall, come do it. Come do it. I don't have a link to Nicoletta. I don't have it, so I'm not posting it. I'm doing all the panels. I'll be late to all of them. Yes. Yes. So yeah. So come join me at Matsuri. I really do hope people blow out their attendance numbers, especially if you're fans of Vix. And every person who comes in support of Vic is doing a huge service to Vic, a huge thank you to Anime Matsuri, sending a huge message to the convention community, and frankly, you're gonna have a lot of fun. You really are. Okay. All right, now, final words before we get into the document. I'm letting people filter in before I jump into the document. Otherwise, what do we cover? So, final note, and this is about the relevant topic, which is Funimation documents and the other documents. Many of you have already read parts or all of this document, either through clips or you've seen the whole thing somewhere and you read it for yourself. That's fine. You probably have read opinions about these documents. That's great. I am here to read the documents. I've skimmed this. I have not read this thing in its entirety. So we're going to be reading it together, reacting, going through it, looking at the argument, and trying to discern what's in the documents. That's what I'm here to do. If people think I'm here to either apologize for Ty Beard's work or be extra critical of Ty Beard's work, that's not what I'm here to do. These are legal documents. We read through the legal documents and I give you my unbridled thoughts as we go. If you disagree with me, great. If you think something was great that I don't, if you think something was bad that I don't, that's also fine. But I know people probably have a whole list of expectations about what this is going to be. But there's nothing that you or I can say that will make any of the stuff going on in this case happen in any different way. It's going to happen this way. This is what we've got. So I hope that you get what I'm saying here. It's not my job to apologize for some of the bad stuff that's in these documents. And I know there are errors in the documents. From the skimming, from reading online, I know we're going to find typos. We're going to find mistakes. We're going to be looking and pointing those out. We're going to be pointing out the substantive mistakes as well. And that's that. This is not a, you know, we're going to apologize for everything that's in there stream, because I had nothing to do with it. So that's a big part of it. And then we're going to just see what the documents are. And we'll try and figure out the meat of the documents. What is the legal strategy involved? What is the purpose they're going for? Is there some angle that we see that they don't? Is there some angle that they see that we don't? All of that stuff. So. There was one last thing I wanted to say. Oh, besides Mike Dunford is fat and dumb. That was one thing. What was the other thing I wanted to say? Oh, yes. There's been some hubbub. I don't know if it's much. It's impossible to tell on the internet how much hubbub there is usually. There's some hubbub about whether these are replies or sur-replies or whatever. I think that these are titled as sur-replies, and I think that might be the incorrect title. I don't know. And I'm couching a lot of this, so just bear with me. Typically, you have a brief, a response, and a reply. We talked about this back when I initially thought that Funimation or whoever might have exceeded their word count. You have brief, response, reply. And then you have something called a surreply beyond that. Now, whether or not they intended it this way, it doesn't really matter. I don't know that the court is going to have any problem with it being titled a surreply if it's actually a reply. And if they do, typically, and if they have a problem with just about anything in this document that's not super egregious, what they would do is they would inform the filing party, hey, you have 12 to 72 hours to fix this issue. Just amend it. This isn't a surreply, this is a reply. Okay, they can amend it. Or the court will go, we don't care, we know what this is. And then the other possibility is that there's some talk about this being over the word count. And by this, I mean the aggregate total of all of the briefings being over the word count, which I believe it is technically over the 27,000 word aggregate maximum. Now, the courts have flexibility on that if they want to, because the courts can do whatever they want. But one remedy they can do is they could say, you're over the word count, so anything beyond the word count is considered a surreply. So until the court actually weighs in on the nature of reply versus surreply, I'm not going to focus on it because I'd just be speculating. And my go-to is that the court doesn't give a shit. And I think that's going to be most of the things that are issues that you come across in this document, or that I come across in this document, is probably going to be court doesn't give a shit. If I have a different opinion, I'll certainly let you know. But when the court does give a shit, they have the opportunity to kick it back to the party and say, you have this many hours to fix this issue. If you fix this issue in this many hours and refile, it's fine. And the reason that they do this is because all of these things, and by these things, I mean these cases, they come with tons of documents, thousands of words, and they know that in the process, people aren't perfect and things get mixed up. And if it's bad enough to be a problem for the record, they often will let people remedy it. And remember, when the other side just missed their filing date entirely, the court said, hey, just so you know, you missed your filing deadline. You probably want to go ahead and take care of that. So I don't think we've got a court that's super militant like we do in the Keemstar versus Lacoste case, right? In the Keemstar versus Lacoste case, the Central District of California federal court, that guy's kicking back documents left and right. But even when he did that, he gave the filing party a time frame to respond. They missed the response, so he yelled at him, and then they asked for reconsideration. He went ahead and said, okay, yeah, fine, you're in. You're back in. So the courts do work with the attorneys on both sides because they're supposed to be in the interest of finding justice. And that's a really important thing. It's important enough to actually be in the Texas Rules of Appellate Procedure that the rules are to be liberally construed in the purposes of serving justice. So if anyone's got their panties in a bunch about a specific little thing that they think is really wrong, as far as the court goes, let's wait till the court says something is really terrible. We can laugh all we want at it. But before we go into apocalyptic, a typo is going to lose the case. Pro tip, it's not. Let's just wait for the court on that stuff. Laugh, though. If there's some funny stuff in here, oh, we be laughing. So let's hit these first super chats, and then let's get to it. Jorel Navarro says, hey, Nick. Ron, I think he means Ron, has said that his insurance is helping with his court costs. What insurance helps with that? I could understand it for a person like a millionaire, but a pissant like Ron, press X to doubt. Well, your umbrella insurance policy, which is actually, if you own a home, you probably want to talk to your insurance person. I'm not a licensed insurance producer anymore, but you probably want to talk to your insurance person about an umbrella liability policy, and those do protect usually against negligent torts, something like and they go above your house's limits. So something like a kid falls and busts his arm in your driveway or something. You want this umbrella policy, will go ahead and cover it. They also cover other types of negligent torts that don't happen on your property. They tend to not cover intentional torts. So it is possible that insurance is helping out with the court with the court costs in some way. There is likely some sort of limit. Without knowing exactly what's in there, what's in the policy, it's hard to say. But defamation is something that is coverable by some of these umbrella policies, and you may want to. That's something that people might want to start thinking about more as they get into the world of the internet and online discussions, especially if you're online talking about people in any sort of public way, like me, for example, right? I would want to talk to my insurance guy about an umbrella policy if I didn't already have a pretty significant umbrella policy. And you'd be shocked at how inexpensive they are. They're really not that expensive. But with that comes various limitations. Without knowing those limitations, we can't actually assess the validity of Ron's claims. What I can say is that Ron seems to be extremely, extremely confused. If his attorneys have billed $280,000, Ron winning $100,000 means that Ron's attorneys will get $100,000 unless Ron has paid more than the difference between that, more than $180,000. Does that make sense? As long as Ron's balance to his attorneys has more than $100,000, he will get 0 pennies from that. He is liable to his attorneys for the entire amount. He doesn't get to get the money and then give it to his attorneys. Usually it would go to his attorneys first, and then they would distribute the money after they take the fees out of the account. Now, they may have some alternative arrangement where Lemon said he doesn't need to get paid, and I highly, highly doubt that. Now, what is another theoretical possibility is that the $100,000 goes to Lemoyne and Co., and then they forgive the remainder of the debt, which is fine, which then Ron would have to claim on his taxes as income. That's another reality that would be taking place. But especially since they've been in court talking about it, talking about getting this or being charged these fees and being invoiced these fees, if they then get that debt forgiven, having debt forgiven is income in the eyes of the IRS. And so they would have to figure out something to do with that. Either, amortize the forgiveness over years or something. That's up to them. And it would only really come into play if they get audited. It's not something that is likely to come up, but it could, and it could be a big mess if it's not handled appropriately. Now, they're working with a lawyer. Whatever they end up doing is probably going to be handled relatively appropriately. But I think Ron is stuck in this weird place where he thinks that he's going to gain dollars from this lawsuit, which is an unlikely outcome, that he would be gaining much, if anything. But yeah, that was a rambling answer. But short summary answer, having insurance that covers defamation is a possibility. Now, if you lose a defamation case and they determine that it was intentional rather than negligent, which this would end up being because it involves Vic, and Vic will likely be found a public figure, at least a limited purpose public figure, according to my thoughts as this case is developed. I think that's a very real possibility. That means that it has to be made with malice, which would be the intentional act of defamation rather than the negligence standard of normal defamation. If you lose a defamation case, your insurance likely doesn't cover that. So it's very important that they win for them. If they have insurance, he could just be lying, but I don't have enough information. Plastic Castle says Lemoyne sings Devo. It's a consulate and a thong. You must whip it. When a mosquito takes your lung, you must whip it. When you have to deal with Ron, you must whip it. I say whip it. Whip it good. There you go. Squally says, I'm lazy. Please read the documents for me, boomer. I'm about to. And Candorous Ordo says, so what does Sir Reply mean? And can I use it to impress my new boss in my science lab? Or would that be like Sakura Haruno? Don't use it to impress your boss in your science lab. Don't do that. It would not have anything to do with a Sir Reply. A Sir being from, well, at least French, but probably Latin for on top of. This is a reply on top of the total briefings, would be a Sir Reply, which is why it's very possible that these are mislabeled. And if they are mislabeled Sir Reply, the court will either not care or the court will likely just say, hey, you need to properly label this. And they kick it back. And then they go ahead and change that. And then everybody's happy. So, Sakaki Onsai says, here's an Andrew Jackson to serve two purposes. One, to piss off Feral Cat and make him have an aneurysm. Why? Poor Feral Cat. Two, to honor the 10 years in prison that the protesters in DC are going to get for trying to take down Andrew Jackson's statue. I hope Old Hickory landed on someone and didn't kill them, but caused them some distress. Okay, let me see if I've got this framed right. And I don't. Here we go. So this is the Funimation reply. Now the overall length of this is 31 PDF pages, but we're gonna skip a couple pages. There's not much for us to do on some of them. Heresy is down. Now, here we go. So, of course, this is Beard and Harris, Ty Beard and Carrie Christie are the attorneys of record on this, and Martinez Sue. We have Michael Martinez, Anli Sue, and Ryan Sellers as the attorneys from Martinez Sue. Table of contents. I'm not going to go through this because we're going to see all this in the document, of course. Index of authorities, same thing. We're going to see them in the document. As a brief note, all of these should probably be italicized. I don't think the appeals court is going to care, but proper citation format should have these italicized, the case names italicized. Here's how annoying legal writing is. When you put a case citation in a case, documents for a motion or briefing, you're typically italicizing them. When you put them in a law review article or a scholarly paper, you have to underline them. This one has neither, and I have to imagine that has something to do with just the transferring them, copy and pasting them into Word is probably the issue, but they should be italicized in the index of authorities, and they should be italicized in the document and in the footnotes as well. So, looking for italicized period is a bitch. Yes, that's actually really just a funny side note. When you do them and italicize them, the punctuation that follows the case name, like here, Turner versus KTRK Television, for example, comma, Inc., period, comma. The comma and the first period should be italicized, and this second comma should not. And changing it and doing all that shit is a pain, and I hate it. So here we go. Issues presented. Says the trial court's finding that Vic is a public figure led the trial court to commit reversible error in dismissing Vic's defamation claim against Funimation. Yes. Now, remember, another thing to bear in mind in any legal document, and especially in these appellate documents, you can have multiple issues that even conflict with each other or don't rely on each other. So the idea is that finding him a public figure did lead to an improper conclusion that it should be dismissed. But even if they do find him a public figure, the rest of the arguments will proceed on the assumption that they do or don't, or that's how it should be written. We'll have to go ahead and check. Funimation LLC's published tweets are reasonably construed as an accusation of sexual misconduct against Vic. Yes, I agree. Sufficient evidence was properly before the trial court to support each of Vic's claims. Yes, I agree. And the trial court committed reversible error in awarding Funimation LLC's attorney's fees and expenses, which we're going to find out that the argument here is that they shouldn't have dismissed the case. Therefore, they shouldn't have awarded fees. But it's very clear in the law that if they do dismiss the causes of action, that fees and costs are part of that award. So the way it's worded is like, oh man, but it was dismissed. Of course they should have. Of course they should have awarded attorneys' fees and expenses. And yes, but remember, the whole idea of this document is to overturn the entire thing. And you want to make sure you point out that, yeah, if you're overturning this and we're going back, then you need to also reverse the fee award because it's not proper at that point. Okay, reply to the statement of facts. This is an interesting section that they have put into each brief, and I like it. I like it a lot because what they do here is, and again, I've skimmed these, but I haven't read the full details. You know, that's what I'm saying. So I know the gist of what's going on. But the reply to the statement of facts is this place where they took some time and they took some words and they go ahead and point out where the other side is not acting with candor towards the court. And this is an important thing. It's the other side is actually misrepresenting to this appellate court what is going on. Now, of course, the appellate court has the record. They have all the trial court findings. And they have a duty to go through and make sure they're familiar with the record and all of that stuff to a point. But you're talking thousands of pages. And so if they miss some of the factual nuances or the thrust of it from the original, the lower court briefings, it's the duty of both parties to tell the appeals court the basic story. And if one side is telling them the wrong facts, and those facts are material, you want to point it out. So this is a cool section, in my opinion. And I was happy to see it in here because I know when I was reading through the response briefs from the defendants, I was annoyed at how many times they were actually misrepresenting what happened. So to see that get called out, I think is a good thing here. Okay, Victor Mignogna maintains and refers this court to his statement of facts in appellant's brief. Vic provides this reply to bring this court's attention to Appellee Funimation LLC's unsupported or unfairly distorted factual allegations and to highlight the importance of certain critical facts. While Vic is a career voice actor, Funimation's statement about Vic's prominence is exaggerated. Now, most of these footnotes I'm not going to go to because they're just citations to the record, and going into the clerk's record would be a substantial amount of showtime, and it's not really. I mean, we're going to get the idea from the statement of facts here, so we're not going to. We haven't done that in the other cases, and I don't really want to do it on these as well because we will be lost in the weeds. Okay. Vic provides voice acting for English dubs of Japanese animated cartoons or anime. Fans of the genre, the anime community often attend conventions. The members of the anime community post news and information they find relevant on internet websites. but nothing in the record establishes that Vic has any prominence whatsoever in the general public that would justify treating him as a public figure. And they're talking about a general purpose public figure here. And again, the way you kind of understand that is that someone is so broadly and ubiquitously known that their life becomes interesting of its own existence. So think of TMZ and the paparazzi. Who are they following around trying to take pictures of? Then you start to get an idea of who public figures are, right? Justin Bieber is news, I guess, or was at least for a time. People like Tom Cruise or the Robert Downey Jr., you know, their lives and the activities in them that could be, you know, eventful but relatively mundane for a normal person, like say going to rehab, becomes a public interest event. Those are the type of people that are going, you know, that we're looking at here and saying, are these are public figures. So here's a question for a general purpose public figure. If Jamie Markey went to fat camp, would there be news about it? No. No one cares if she gets the help she needs. Nobody on earth gives a shit what Jamie Markey does as far as her weight issue. All right? So that's a big sort of indicator of what is a general purpose public figure. Now that's different from a limited purpose public figure, and that's going to get into it a little bit. Or I assume they're going to get into that in a little bit, but that's going to get more into the facts of what happened in this particular case to determine that this person is or isn't a public figure for the purpose of this lawsuit. Whether or not they're generally known becomes irrelevant at that point. Oh, hey, what's up, Uncivil Law? How's it going, buddy? But nothing in the record establishes that Vic has any prominence whatsoever in the general public that would justify treating him as a public figure. Put another way, there's no evidence in the record that establishes Vic's prominence outside of the anime community. And this is not the argument section. This is a fact summary section. And being honest, I don't know if overall they have done an effective job of communicating this, but it's pretty hard to communicate a negative, so I'm not going to be too terribly critical on it. I think they are fairly asserting that there is not enough evidence in the record to establish Vic as a general purpose public figure unless you intentionally misconstrue that evidence to mean, oh, well, he was in some movies. That means everybody knows who he is. But these people could not identify Vic Mignogna in a crowd. He's not Jay Leno or David Letterman or William Shatner. As much as he might want to be William Shatner, he's not. And so he's not ubiquitously known like that. The question around this, though, is kind of evolving quite a bit in the internet age because it's really easy for normal people to amass a level of prominence that they've never amassed before. And just taking my stupid self as an example, I have 83,000 subscribers on YouTube. Does that make me a general purpose public figure? I mean, I would say no, because I can walk through my town and no one goes, hey, you're that asshole making fun of fat people on YouTube. No one does that. They should, but they don't. So I can suggest that I don't have that level of prominence. But at the same time, you take a normal person, you say, hey, 80 something thousand people might know who this guy is. And that's a big number. And at the time that public figure doctrine was really fleshed out, New York Times versus Sullivan back in the 70s, you didn't have the same, obviously you didn't have the same publicity tools that we have now. And it wasn't so easy. I mean, the crazy thing is PewDiePie is a public figure. He's one of the most widely subscribed people on earth. But if you walked around to adults, for example, in America, and said, hey, could you know, and showed them a lineup of 4 pictures and one of them's PewDiePie, I bet most of them could not point at PewDiePie and say that's him. But you got 106 million or whatever subscribers on YouTube. You've got to be a public figure, right? So the line on this is really muddy, and courts are going to have to suss it out. As for whether or not, I don't think he's a general purpose public figure at all. I think to argue that he is a problem. Limited purpose public figure is very much in the realm of possibility, though. But I do think they did not put any evidence in the record to establish his prominence outside the anime community. And they had opportunities to do so, in my opinion. They did have the opportunity to mention that he's a music producer, that actually the Fort Worth Court of Appeals and the Fort Worth District Courts, that their staff has probably heard music that he's produced. They could have made better arguments there about that. I don't think they did. But I think really they were focused more on a limited purpose public figure argument, and they should have been. More importantly, nothing in the record shows that the resolution of the parties' dispute would have any significant impact on any members of the anime community or the general public. And this is, they're citing Hoskins versus Fuchs. I haven't read this case, but if I take their assessment of the case as true, that's a pretty interesting qualification for a general purpose public figure. If Vic is victorious, or if Vic fails in this, what impact does that have on the members of the anime community at all? Very little, I think. That's at this point, it's very little. If it would have been resolved quickly, there may have been some impact. I don't know. But I don't think they've put anything in the record to state that it would have a big impact. And that might be an error on their part. Now, again, I'm not familiar with Hoskins v. Fuchs, but if I take their assessment as true, that could be an interesting point. But I can't put any weight on it. Candorous Ordo says, can't wait. Tai Teal Nukes Taku about how you pronounce Sakura's maiden name, because there are no Sakura fans. Okay. I don't know what that means. Okay. Despite Funimation's characterization to the contrary, Vic's January 20th, 2019 tweet is not properly considered an apology or any kind of admission of any sexual assault, harassment, or misconduct. I agree. They've completely misrepresented the apology, and the words of the apology are grossly mischaracterized in their brief. In the January 20th, 2019 tweet, Vic specifically denies several specific allegations against him. Any allegations of sexual harassment, sexual assault, or most disturbingly, pedophilia are completely and utterly false. My heart weeps for any who endures a violation of this kind. So to be accused of harming others in this way, I have no words. The only apology was for an unrelated comment made years ago, and that was about the Holocaust comment. The sort of known line about where it sounded like a Holocaust in there, and they're like, he means they're burning Jews! Which that's just how some people are, I guess. But he clarified that, and he also said, you know, if anybody ever walked away from his booth with some sort of negative experience, that he was sorry about that. That, you know, that's not the experience he tries to provide. But he does categorically deny any of this stuff. To characterize it as an apology for what they're accusing him of is disingenuous, and going by the words of Monica and Ron Toye, and even the words Ron Toye maintains to this day, as he described in his Knuckleheads interview. Going by those words, you know, Ron said if you take it this way, Ron said if he just apologized and did these things, that he'd be welcome back in. Monica also said that. And then they said, well, he apologized. But he didn't apologize. But then even if he did, they didn't follow through on their thing. So it's a stupid mess. But anyway, the question, though, and I think this is a valid question, is does this tweet, is this sufficient participation for Vic to be considered a limited purpose public figure? And that, I think they're going to have to maybe have a debate about it, oral argument. But if it is, I think that's a dangerous, and it may be. I'm not saying it isn't or is, I don't know. the court will have to clarify if this is sufficient. Well, they may not have to. The court may clarify if this is sufficient participation. But I think it's very dangerous to say that if you make any statement to defend yourself against any negative allegation, that is public participation sufficient to make you a limited purpose public figure. Because if you think about it this way, a woman or man can scream in a mall, "He grabbed my breasts." And you could say, "No, I didn't." And they say, "Wait, he grabbed my butt." And then you don't say anything and you sue them for the defamation because you get beat up or whatever. And then they said, "Well, he denied grabbing my breasts. Therefore, he participated in the discussion about his ongoing sexual harassment. Therefore, when I said he grabbed my butt, that means he's a limited purpose public figure." Well, that's fucking ridiculous, right? And it is an absurd comparison, but it's apt. It's apt here. Funimation's, but the idea that you can't defend yourself without in one statement without becoming a public figure is troubling, and it may be the law. That's the scary part of it. This is not a concrete area that says that, you know, there's like a checkbox of what makes you automatically a limited purpose public figure. There's some guidelines for it, and it has to be reasoned at the trial court. The biggest thing Vic's got going for him in the trial court thing, in as far as the public figure doctrine goes, is that Chup's ruling on why Vic's a public figure, the only thing he says about it of any substance was at the hearing when he said, not that many people come for hearings normally. That's a bit ridiculous. Funimation's tweets specifically reference the Mignana situation on Twitter, where the only fair reading and understanding of the Mignana situation is the sexual assault allegations against Vic. Funimation's assertions that the tweets were truthful puts the cart before the horse. Vic vehemently denied the allegations on Twitter, which is all that's necessary to defeat a TCPA motion. I don't think that's all that's necessary, but I think what they're saying is, in brief, and we'll probably get to it in the argument, I hope, will be something along the lines of his denial sets up a fact question that must be resolved in his favor for the purposes of the TCPA. I think that's language we're probably going to see in a little bit, but we'll move on. Funimation claimed that it conducted an investigation into the allegations of sexual assault by Vic. The only fair reading and understanding of Funimation's tweets is that Funimation concluded that the allegations that he committed sexual harassment and sexual assault were credible and were the basis for terminating his employment and excluding him from future productions. The record is clear as to Funimation's meaning by investigation, which I think is some sort of slam on it. Candorous Ordo says, "I see you are not subbed to Nukes Taku. That's perfectly fair." No, I'm not. I have no idea who that is. What is that? Oh, Vic's February 13th, 2019 tweet is not an admission as to the accusations against him or of any other wrongdoing. The tweet is a simple statement about Vic's appreciation for the anime community and that he had never believed he had harmed or hurt anyone, stating, "Until these last few weeks, I had no idea that any animosity ever existed." So there you go. That is their statement against Funimation's representation. Summary of their argument. Funimation assumes without evidence that Vic is a public figure. The only evidence offered to the trial court in support of Funimation's argument that Vic is a public figure is that 1, that Vic provided voice acting work on the production of Dragonball Super Broly. 2, that Vic has an IMDb page detailing his career from 1972 to present. And 3, the number of Vic's Twitter followers. 4, websites, articles regarding the tweets from Appelese, Monica Rial, Ron Toye, Jamie Markey, and Funimation. And 5, an affidavit from Funimation's Director of Public Relations claiming the existence of certain hashtags on Twitter. This evidence does not rise to the level necessary to establish Vic as a general-purpose public figure. The existence of discussion of a particular topic on the internet cannot, by itself, make someone a public figure. Funimation failed to provide the trial court with any evidence that the resolution of this dispute would impact any particular person's decision to attend a convention or view a particular production. And in fairness to Funimation and the defendants, I think they probably could provide that evidence. I think many of you are evidence of how that would work, but I don't think that they actually did. And there was a rampant amount of it at the time, especially as, remembering when the initial trial court briefs were going on. The court should reverse the trial court's dismissal of Vic's claims against Funimation because the trial court was presented clear and specific evidence supporting each element of each claim as required by the Texas Citizens Participation Act. Specifically, and this is an interesting angle that I'm glad they're harping on more in the reply brief than they did in the initial brief. Funimation's own motion to dismiss offered testimony and evidence by and from Vic denying Funimation's allegations. Funimation offered Vic's tweet claiming that any allegations of sexual harassment, sexual assault, or most disturbingly, pedophilia are completely and utterly false. And this is what I was talking about earlier. They set up a fact question, and for the purposes of TCPA, that fact question should be resolved in favor of Vic Mignogna because he's the non-moving party. That's just the way the TCPA functions. It's one of the small mercies you're offered as a plaintiff in a TCPA case. Funimation's attempts to argue that because its tweets are truthful, it should succeed on its TCPA motion when in fact the proper analysis is not whether the tweets are truthful, which is a question of fact that must be decided at trial, but whether Vic provided sufficient rebuttal evidence, namely his denial of the truthfulness of Funimation's tweets to defeat the TCPA motion. The short answer to that question is yes. Vic provided sufficient evidence to dispute the truth defense and thus defeat the TCPA motion. Funimation argues that its tweets cannot be reasonably construed as allegations of sexual assault. Again, Funimation's own TCP evidence is fatal to its argument. Specifically, Funimation Vice President of Operations Karen Mika states in her affidavit that Vic was terminated based on the results of an investigation prompted by social media posts on Twitter. The tweets prompting Funimation's investigation were an accusation made by Han Lea against Ilik Guardiola and accusations of sexual harassment leveled against Vic by Appellees Rial and Toye. And Markey. Funimation's tweets can only be read as responses to the various tweets accusing Vic of sexual misconduct and demanding action by Funimation. Indeed, as noted above, Funimation's Vice President of Operations Karen Mika confirms that investigation was prompted by social media posts on Twitter. Funimation, which is not... I don't believe that's true. I'm pretty sure that's a lie from Karen Mika. Because I'm pretty sure they were prompted by Monica Rial bringing them to Karen Mika's attention. But maybe not. If only we had access to that investigation and if only discovery had been provided on that front, we would know. But for now, we don't. Funimation's... Oh, no! Well, they lose the case. Look at that. Son of a bitch. Document was going so well. Now we quit. No, I'm just kidding. Funimation, scratch that, not only terminated Vic, but also tweeted to its thousands of followers an, quote, update on the Vic Mignogna situation. Funimation's tweet stated Funimation would not be engaging Vic in any future productions. This tweet alone can be rationally inferred by a member of the general public as an accusation against Vic of sexual misconduct, which is defamation per se. And this is really the crux of the argument, and where frankly, I hope the appeals court sees it the same way. Funimation, had they said nothing, they could have fired Vic all day. Had they just said Funimation will no longer be working with Vic Mignogna, they would have been fine. Even had they said, following an investigation, Funimation will no longer be working with Vic Mignogna. Probably shouldn't say that. If you are a corporate client with a corporate attorney, they would suggest that you don't say that. Why bother telling people why you're firing someone? Hell, lots of HR departments will not even confirm someone was terminated. They will just confirm employment dates because of the risk of a defamation suit. But it's the totality of the tweet, which is the legal term in Texas is the gist of the total publication that says, update on the Vic Mignogna situation, which calls into the community's zeitgeist about Vic Mignogna. They're talking about the articles that are coming out and the tweets that they're monitoring. They're calling attention to those. Those are about acute accusations of sexual misconduct. Then they say the investigation. Then they say they won't be engaging him anymore. And anybody who reads that, and I dare say everybody who read that, said they investigated Vic for sexual allegations of sexual misconduct and found him guilty enough to fire him. And if you want to say that it's not that, I will call you a liar to your face. Of course, people thought that. Monica even thought that as she replied in that thread. So yes, that is true. Did they bring this up sufficiently in their briefing? I hope so. We'll have to see what the court says. But I think they're really trying to hammer home to the appeals court is, if you read this statement, how would you take it? Of course you're going to take it this way. This tweet alone can be rationally inferred by a member of the general public as an accusation against Vic of sexual misconduct, which is defamation per se. Funimation, however, confirms the reference to sexual misconduct allegedly committed by Vic with a second tweet stating that it does not condone harassment or threatening behavior being directed at anyone. Now, Funimation denies that that's what that statement was about. That's a fact question. That's not a legal question. And fact questions, when there's disputed facts, must be resolved in favor of the plaintiff. They've raised this issue several times. It's the core of the argument against Funimation. And so if they resolve that in favor of Vic, that second follow-up tweet is part of the publication and is specifically referencing harassment and threatening behavior of Vic that they're alleging, then it should get past TCPA, or it should be sufficient for that portion of defamation law. Again, will the appeals court see it that way is a different question. It should be sufficient. And the trial court, this is one of the big things that comes up in these documents. I'm not sure if it's fully in the Funimation document, but I know it's heavy in the Real and Toye one, is there are several fact questions that Judge Chupp did not render in favor of Vic Mignogna, and he should have. In fact, he's required to, and that alone should be sufficient to overcome things. But again, in the hands of the appellate court. Yeah, that second tweet reinforces the first one. I agree. It's also directly replying to the first one, and it's like minutes away. Oh, hey, what's up, Ty? I'm just here criticizing your work. 1 second. Sorry, guys. Had to take care of something real quick. All right, back to it. My apologies for the unprofessionalism. By the way, Ty, you bastard. How do you explain yourself? Leaving an apostrophe S in there. Just ridiculous. Funimation's tweets were entirely gratuitous and unnecessary. I fully agree. As to Vic's causes of action for tortious interference with existing and prospective business contracts with anime convictions, vicarious liability as to the tweets by Rial and Markey, and conspiracy, the trial court was presented with sufficient evidence of each, as was argued in Vic's appellant brief filed in this court. This is an indication. If you're not reading between the lines here, the argument that Funimation is independently liable for any of these things, the conspiracy or the tortious interference with existing contracts and the prospective business relations, the evidence against Funimation for those in and of itself, it has always been weak. It's always been predicated on the idea of conspiracy or vicarious liability for their employees. So they're not going to waste a lot of word count on it here. And that's just the hint. Look, if you find conspiracy and vicarious liability and you find sufficient grounds to carry on with those at the going back to the district court on remand, then sure. Yes. But those against Funimation on their own, I believe, are unsupported by the evidence that's presented. And reasons for that, well, one of them is simply when you sue someone, you don't always have all the information and you sometimes hope you're going to uncover more. And I imagine they hoped they would find some information like in the discovery requests that would allow them, the opportunity to get that info from Funimation. But Funimation refused to turn it over, and then they filed their TCPA prior to their deadline, and that's all she wrote. Argument. Trial court's finding that Vic is a public figure led the trial court to commit reversible error in dismissing Vic's defamation claim against Funimation. The trial court found improperly that Vic is a public figure. The trial court's error in finding Vic was a public figure led it to erroneously require Vic to prove actual malice in connection with his defamation claim against Funimation. Oh, see, look down at these footnotes. Here they've got proper italicization going on in the footnotes. So that's much whoops. I didn't mean to line that out. Oh, I can edit this? I will line out your document. Yeah, that's how they're supposed to look. We saw in the table of authorities that they're not done. Again, it's a minor error. Is the court going to have a fit about it? If they do, the remedy will be, hey, fix your table of authorities, you dumbasses, and then they'll get over it. If a plaintiff in a defamation action is a public figure, the plaintiff must show the defendant acted with actual malice in regards to the truth of the statement, and that's citing Lipsky, Carr versus Brasher, and citing New York Times versus Sullivan. If a plaintiff is a private figure, he need only show that the defendant was negligent. For purposes of defamation liability, there are two classes of public figures. One, general purpose public figures, who are individuals who, quote, achieve such pervasive fame or notoriety that they become public figures for all purposes and in all contexts. Like I said, if Jamie Markey goes to fat camp and people give a shit about it, like regular people, then that matters. If Jamie Markey goes to fat camp and no one cares, which is the real case, then she's not a public figure, not a general purpose public figure. She's big, but she's not that famous. There's differences. And two, limited purpose public figures, who are persons who, quote, thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved, inviting attention and comment. That's one section. Who voluntarily inject themselves or are drawn into a particular public controversy, assuming special prominence in the resolution of public questions, and who, quote, thrust themselves into the vortex of a public issue or engage the public's attention in an attempt to influence its outcome. So the question will always be, did Vic's overall participation in the discussion about these allegations, which involves the January 20th, 2019 tweet, the February 13th tweet, and potentially his Discord. Although it is a fan Discord and is arguably not a public forum, but did his participation in those three statements, because that's essentially the gist or the totality of statements that he's made in response at all to this controversy, were those three instances. Did that rise to the level of making him a limited purpose public figure under these definitions? And I think there is plenty of room for reasonable people to disagree on this front. I think because I'm a pessimist and because I hate how the court deals with defamation, I think he is a limited purpose public figure under these under this structure. So then the next question is, did they introduce the evidence sufficiently to bolster that? I don't know if they did, because I frankly don't remember everything that was in their motion documents off the top of my head to put that in front of the court. If they did that, then he might be a limited purpose public figure. He may be. And I've said that for a while. So they are making the argument here, and I think it's necessary to make, but I think it is likely that they can lose on this argument. Funimation supports its claim that Vic is a public figure by asserting that, one, that Vic provided voice acting work on the product Dragonball Super Broly. Who here? I mean, I'm trying to think of how else to do this. Was the animator for Dragonball Super Broly? Like, how many people would know that outside of really, really hardcore anime fans? Now, his work, or their work, those animators, their work is as prominent, if not more prominent, than any voice actor's work in the show. Because it actually goes across the language barrier, right? So if you're watching it in Japanese or in English, you're getting different people. Yeah, Toei Animation, right? But what the artist is what I'm saying. More people will see globally. Many more people will see the artwork of a particular artist than will hear Vic's voice. You will see neither of their faces. You see where I'm going with this? This is the difference between a voice actor and something that all of the defendants have been straying away from. If Vic is an actor with this many public credits and a prominent actor, it pushes much more towards the public figure thing. And that's what they're trying to get to here. Ignoring the fact that almost all voice actors are god-awful actors. Really terrible. Absolutely bad at trying to transcend the fact that they talk in a booth and getting onto stage. And most of them don't make it as any sort of real actor. Real acting credits are different. You're seeing their face. When you're out in public, you can identify them. Plus, there's another problem. And I don't know that this is getting off into the weeds on an argument. And if you have a perfect world and could do everything over and you could do everything my way, which would be a perfect world anyway, you might get into the fact that a voice actor's voice is often obscured from the normal voice that that person brings to the public, right? In public, how does Vic sound? Hi, I'm Vic Mignogna. I love to see you people. I love my fans. And thank you so much for coming out here. How does he sound as Broly? Right? Vastly different voices. Vastly different. And so if you're not following anime with intensity, you don't know that Broly is Edward Elric, is the jackass from Ouran High School. I don't remember what his name is. Sorry. You don't know that. So when they're at a coffee shop, that's not them. Tamaki. Ha! I'm becoming more of a weeb. Oh God, my basement just got bigger. No, I'm just kidding. If you run into them at a coffee shop, you may not know. If you're getting your hair cut by Monica at her hair salon or whatever, you probably have no idea. You're like, oh, what? Okay. So you played Panty or Stocking. I don't remember which one it was. You don't know. Archangel Nation says, Nishan says, hey Nick, quick question about this new development within the Destiny community. Would you be able to do an overview for people on the legality of Orange Justice Group? Curious about how the legal process works on DDoS. I have no idea anything about it. If you email me an article or something, or Twitter DM it, I can try and look into it. I don't know that I'm going to get to it this week, but I can maybe do a short video. I don't know. DDoSing something is probably illegal, but it's also really hard to trace. Candorous Ordo says, I'd love to see Blizzard Entertainment even attempt to hire Neil Kaplan, one of Vic's detractors, as live-action Tychus Finlay in an LA StarCraft movie, or even LA Madara, because he does not look like them at all. So there we go. All right, back to it. So I'm getting way off in the weeds here, but and I want to be very fair to everybody involved. I don't think either side briefed on that issue very heavily. I think it may have been mentioned that he's a voice actor and that he doesn't appear on screen. But, and again, you're talking infinite money, infinite word count, infinite patience, infinite foresight, all of that stuff. You really get this ability to lay a foundation for everything. You hit that argument. I mean, I don't think it's necessary in this case, and I don't know that it would even be overly effective, but I'm just musing here. 2, that Vic has an imdb.com page detailing his career from 1972 to present. 3, that he has a number of Vic Twitter followers. 4, website articles regarding the tweets from Rial, Toye, Jamie Markey, and Funimation. And 5, an affidavit from Funimation's Director of Public Relations. And 6, Vic had a, quote, fan club called Risen Bull Rangers. So there you go. There you go. Funimation's evidence is insufficient to support the trial court's finding that Vic is a general purpose public figure. And I ultimately agree, because I don't think if you walk down the street and talk to 10 people that it's likely that even one of them knows who Vic Mignogna is. They may even know his work and not know who he is. General purpose public figures have assumed so prominent a role in the affairs of society that they have become celebrities. Absent clear evidence of general fame or notoriety and pervasive involvement in the affairs of society, one should not be characterized as a general purpose public figure. Funimation presented no evidence that Vic possesses general fame or pervasive involvement in the affairs of society. Instead, Funimation points to the website articles that include conversation threads between Rial and her fans on Twitter. Funimation's articles show that Rial was using her false accusations against Vic in an effort to gain attention on social media. True, also a slam, and that's a glorious one. Thank you. The same is true of Markey. The sad part for Markey is that no one paid attention to her anyway. Statements by other defendants / appellees do not establish that Vic is a public figure. And that's true. That's true. You don't get to make someone a public figure by defaming them. You don't get to make them, you don't get to draw the public's interest to someone to make them a public figure. That's not how that works. Furthermore, Funimation provides no explanation as to how Vic's voice acting work on the program Dragon Ball Super Broly holds such significance among the movie's fans that the resolution of the accusations against Vic would have any impact on the general public. While Dragon Ball Super Broly was successful for an anime movie in America, the trial court incorrectly concluded that Vic was elevated to the status of public figure from his participation. Did the trial court actually conclude that, or did they just say that he was in the movie? I don't remember the specific wording, but if they did, that's extra stupid. And the extra stupidity of it will be that the next Dragon Ball production featuring Johnny Young Bosch instead of Vic Mignogna as Broly, if they do one, will get relatively similar amounts of attention. And it will have no overall impact. In fact, I don't think that Vic not being Broly in the ongoing series with Super and what, Heroes? Is Broly in Heroes? I don't know. Whatever Johnny Young Bosch's voice acting, frankly, I don't think there's an overall impact on the sales of that. And if this goes back, it certainly doesn't have any impact on the distribution of it, right? Like, well, Funimation distributes Dragon Ball, so they didn't suddenly say, oh, we're not going to distribute Dragon Ball anymore because we lost Vic. Like, it doesn't have any impact on the channels it's on. I don't know, if it's on Netflix or wherever it ended up in the long run, but that has nothing to do with Vic being the voice actor. So what is the impact that is suffered by the resolution of this? That's a good question. While Dragon Ball Super Broly was successful for an anime movie in America, trial court incorrectly concluded that Vic... While Vic provided voice acting for Dragon Ball Super Broly, film is an animated action movie with a limited audience. It does not follow that Vic's voice work on a successful anime movie establishes Vic as a general-purpose public figure. And of course it does not. And while making $30 million in the US is great, and $80 million globally is great, lots of trash does that too. Lots of trash does that as well. So, who knows? There is no evidence that the group of individuals who participate in internet discussions about an accusation against an anime voice actor is so large that it constitutes the general public. Thus, Vic is not a public figure, quote, for all purposes or for all contexts. And that's really, this is the nail in the coffin of general purpose public figures. And if the court were to find that Vic is a general purpose public figure, then we need to probably just regress as a legal society and end everything. Because there's like, that is, well, he's prominent in anime, so he's prominent in the general public. No. And remember, kids still get beat up for liking anime. That still exists. There's still nerds. There's still shut-ins. Hell, Monica Rial and Jamie Markey still refer to anime fans as incels who live in their parents' basement. If you want a derogatory interpretation of anime fans, look no further than the voice actors whose jobs depend on them. Drew A says, would Vic being a public figure be considered a fact question? The public figure doctrine is a mixed question of fact and law. So it is a fact question in a lot of ways, but it's a legal conclusion done at the pre-trial stage. So it is resolved as a matter of law as part of the TCPA. It's actually an essential part of the defendant's case in the TCPA is to establish whether the plaintiff is a public figure or not. And it is a fact question, and they have to prove it by a preponderance of the evidence, and the judge sits as a fact finder for that purpose. That is a bad way to do it. Let me just be very clear. Because when you have a fact finder, you have the tools of discovery at your disposal. And when you're asking the judge to sit as a fact finder at a pre-trial portion where you exclude the tools of discovery, which are the most impactful tools in any lawsuit, and you get rid of that, you can't adequately adjudicate a mixed question of fact and law, much less a question or a question of fact. Certainly not a question of fact, and then the mixed question of fact and law. But is treated as a legal conclusion based on the facts presented at pre-trial. And I think that's a part that really needs to change, because you're cut off from the tools of discovery. So it's a mess. But of course, the idea would be that if they're public enough, discovery isn't necessary. That's, I guess, the thinking and the trade-off. Anyway, next. There's insufficient evidence to support the finding that Vic is a limited purpose public figure. And this is the section I'm much more interested in. To determine whether a person is a limited purpose public figure, Texas courts apply a three-part test. 1. The controversy at issue must be public both in the sense that people are discussing it and in the sense that people other than the immediate participants in the controversy are likely to feel the impact of its resolution. Now, the argument that this is a public discussion is one that I don't know on Texas law, but I know in California, discussions or allegations of pedophilia, which the Vic thing sort of is and sort of isn't. It is by the statement of Han Leia that was misinterpreted. It isn't by the later words of the defendants trying to cover their asses from calling Vic a pedophile without any evidence of it. But the idea that someone is inappropriate with a minor in California, as we saw in the Keemstar lawsuit, is a matter of public concern by itself. The safety of children is a matter of public concern. So that would be the argument, at least, that the controversy or the discussion is a matter of public concern and that it should be had. Doesn't mean you get to lie about people. It just means that, are you exercising your First Amendment rights? Is this a public issue? There are two more parts of the test that will determine if the limited purpose public figure applies to the person involved in the issue. Those are different things. You can have a public issue and not have a limited purpose public figure. Very, very different. 2, the plaintiff must have more than a trivial or tangential role in the controversy, right? I can't just say that Mike Dunford touches little boys, right? And make Mike Dunford a public figure because of the accusation that he touches little boys. I don't think Mike Dunford touches little boys. But if someone were to try and smear him by saying Mike Dunford touches little boys, for example, they would be then creating a public discussion, right? The safety of the children would be a public discussion. Now, if Mike Dunford doesn't react to that and doesn't try and influence the thing, he doesn't make the next two parts of the test, then we have a public discussion, but not a public figure. Okay? Am I making that clear? All right. 2, the plaintiff must have, that's the trivial or tangential role in the controversy. So again, the argument about Vic is that his comments on Discord and then his 2 tweets, the only statements he's made in this entire case, which is shocking that that's the only things they can point to that he said, is that more than trivial or tangential? I don't think so, but will the court think so? 3, the alleged defamation must be germane to the plaintiff's participation in the controversy. So let's see how they argue this. To determine if Vic's role in the controversy was more than tangential, a court examines whether the plaintiff, 1, actually sought controversy, 2, had access to the media. Is Twitter the media? 3, voluntarily engaged in activities that necessarily involve the risk of increased exposure and injury to reputation. There's no evidence Vic established himself as a limited purpose public figure by thrusting or injecting himself into this controversy. I don't recommend thrusting or injecting yourself into a controversy unless it consents. Neil Druckmann. Abby did not consent. You pulled her hair. How dare you? You filthy, filthy man rapist. In fact, Vic testified that he did not seek out this controversy, which must be assumed to be truthful under the TCPA. Before Vic ever published a tweet responding to the accusations against him, he was the victim of numerous false claims of sexual assault and sexual harassment by Rial, Toye, Markey, and Funimation. The controversy's genesis started with a tweet by Han Leia on January 16, 2019. It was misinterpreted as an accusation of sexual assault, harassment, and misconduct against Vic by Funimation. Accusations on Twitter against Vic followed. Vic categorically denied the accusations via tweet on January 19, 2019. Vic's IMB.com page does not make him a public figure. Funimation fails to explain how the existence of an IMDb.com page. This is weird. This belongs in the general purpose public figure section. This seems like a I would put this up above the limited purpose public figure section. I wonder if there was some revisions and cuts going on that left that below the public figure, the limited purpose public figure, because this is like a general purpose argument, it looks like. So that's a weird point, but you know, whatever. Establishes that the resolution of the party's dispute involves a person, namely Vic, whose prominence is so high that the resolution of this dispute will have an impact on the general public. Okay, Funimation fails to explain that. Funimation fails to establish that any particular degree of recognition or fame is required to have an IMDb page, nor is such recognition demonstrated by the contents of Vic's IMDb page. Funimation's evidence of website blogs is not sufficient to establish Vic as a public figure. Many of the blogs were published after Funimation published tweets accusing Vic of sexual harassment and sexual assault. Funimation would have the court believe that these blogs are evidence of Vic's status in the public. However, the existence of website blogs, which were first published after Funimation's tweet about Vic, is just as easily attributed to Funimation's status as an expansive media company and subsidiary of Sony as it is to any alleged fame held by Vic. This is correct. I mean, legally, I'm not saying this is legally correct. I'm saying that the analysis of this is correct. It's impossible to say whether these publications were interested in Vic independent of his role in anime, or if they were interested in the anime community itself, being that these are trade articles in Anime News Network and then IO9 in the anime and gaming section. These are trade publications, so to speak, in some sense, and therefore they're speaking into that community. So are they following Vic, or are they following news about Funimation and their activity? Those are different questions. I don't know if that's fully fleshed out here. I don't know if that's sufficiently briefed. And again, if I could wave a wand and revise everything that has ever been filed in this case to my liking with infinite time and money, I would maybe spend a lot of time focusing on the fact that the publications that they brought up are intentionally targeted to a limited community. They're not broad distributions. Let's see. As an expansive media company and subsidiary of Sony as it is to any alleged fame held by Vic. And that would be the question. How often has Anime News Network or IO9 reported on Vic himself prior to this? That would be the type of evidence you... No. He's famous of his own right. Look at this article and this article and this article about him. In fact, what Funimation and the other defendants probably should have done is gone and found any articles about Vic Mignogna that predate the controversy at all. Particularly his Star Trek Continues stuff was a ripe open fruit for them to pillage if they just had gone after other articles. Look at this guy. He's getting published in articles about Star Trek Continues, maybe in articles about Christianity. I don't know if that's true. Maybe in articles about music production. These are the types of things they should have looked for to establish that he was a public figure in his own right. And they could have done that. And if I were their attorney on their side with infinite time and money, that's where I would have gone. But I didn't want to do that. John Volney here for the defendant Funimation. Yeah, Volney could have done that. He didn't take the time. No, I did not. I did not see the alleged murder of someone in chat, and I'm disappointed that I did. Okay. While Vic did testify that he has a fan club called the Risen Bull Rangers, there's no showing that the fan club was of any significant prominence. To the contrary, Vic testified that it just started as just two women who liked a show in which Vic Mignogna provided voice acting. There was no evidence before the trial court to suggest this small group of individuals was significant in terms of scale of individuals, activity, or public participation, such it would have any tendency to establish Vic as a public figure. And that's true. They did not do that. They just said he has a fan club, therefore he is famous. Which is not the way you establish that. The trial court's order to dismissing Vic's claims stated that this case was factually similar to the facts in this court's recent opinion in Lane versus Ferris. So this is the limited purpose public figure argument again. We're back to that. And these two, was it 2 or 3? These 3 paragraphs to me seemed out of place. I would have put them before the limited purpose public figure argument. And that probably, if I had to guess, there was some reformatting going on, and the one paragraph just got pushed up above these or something like that. But anyway, not a huge deal. And we're now getting back to it. It's like the Greek technique of starting in medias res or whatever. Okay. The facts in Lane versus Ferris do not support and are not similar to the evidence Funimation submitted in its attempt to establish Vic as a public figure. Minor criticism here. This Funimation '(S) is like Funimation has, and you should not use contractions in professional documents. Now, the problem, of course, is that no spell check or anything, or even a grammar check is going to catch this, because it could be taken as a contraction for Funimation has submitted. But it should be clarified that that's Funimation has, in my opinion, humble nitpicky opinion there, submitted in its attempt to establish Vic as a public figure. And I agree. The facts of this case and Vic's are vastly different, mainly in the activity of the plaintiff. In Lane, the appellant, a UNT University of North Texas opera and voice professor, sued a student for defamation based on the student's disparaging social media posts. In her motion seeking dismissal under the TCPA, the student appellee offered 1, appellant's professional website, 2, appellant's faculty page on UNT's website, 3, appellee's affidavit, and 4, statements from appellee's deposition. Additionally, the trial court in Lane considered appellant's affidavit. The appellant's professional website, and faculty page contained appellant's own statements reporting her acclaim, renown among the public, and recognitions. There are 2 important differences between Lane versus Ferris in this case. First, in Lane, the appellee presented evidence showing how the resolution of the dispute would impact other people, while Funimation did not. Second, there was no evidence showing Vic's occupation as a voice actor earned him the level of fame as was shown and critically agreed to by the appellee in Lane. Now, this is debatable. If, again, honesty and an attempt at, with my obvious bias towards Vic, and my attempt at objectivity, I think that you could say that statements that Vic made in his deposition or that were made in the pleadings about the level of success he's had as a voice actor could be taken as admissions. I don't think they're strong, but again, I think that the court is just completely boned on how they view limited purpose public figures or public figures in general. And I think that that's why in the end, they're going to say that Vic is a limited purpose public figure. I really do think that the court will come to that conclusion. I hope they don't, but I'm a pessimist on that issue in particular, mainly because I think it needs to be reworked. And Clarence Thomas agrees with me. Don't at me, you bitches. In Lane, the substance of appellee's statements about appellant went to appellant's fitness for and performance as an opera instructor and professor. Now that's important because the statements about Vic have nothing to do with his fitness as a voice actor, right? They don't. It's a factual difference, and I think that's important here because while I'm making these other arguments and pointing out things as it comes to me, it is important to remember that what they're doing here is drawing factual distinctions between Ferris and the Vic case. Appellant in Lane was famous in the world of opera performances and instruction, and her fame was such that the resolution of the accusations against her would impact students' decisions on whether to seek her out as an instructor. Now, a little classist here, but I want you guys to noodle through this with me and think about this. And in a way, they're doing this. And I don't know if they're going to continue doing this, but it almost, if you could go back, it might be something to do a little more on drawing the distinction between Lane versus Ferris. Do you think a judge is more likely to go to an opera or to go to Dragon Ball Super Broly? Think of a judge, and you've got upper middle class to upper class, white, middle-aged to elderly male, largely. What do you think they're going to go see? Affluent, rich, white man, probably opera, before they're going to go to Dragon Ball. And that may have been a factor in Lane versus Ferris. If she was a voice acting instructor, teaching kids how to do anime, it could have gone differently. It's very possible that the judges knew this person, have seen their work. And again, maybe that's a trick that you have to put in there subtly to fool the old person on the bench. That's a trick that you got to do. And I don't know how you do it or what degree you do it, but there's a distinction here. Anime is not opera. And judges are people, and they assume, like everybody does when they're just not thinking about it, that their experiences are normal. Like, they go to the theater, to see live productions. They spend hundreds of dollars in tickets. They go to political fundraisers. They hobnob at black tie affairs. That's what they do. Do you guys? I like to. I get to maybe do one black tie event a year, and it's fun. I like to dress up and pretend to be important. But generally I don't, you know? But judges do. They're elected in Texas. That's a factor, a function of their employment and their ongoing ability to maintain that employment. So I think that might have played into Lane versus Ferris as well. But here, the important distinction is that they didn't actually determine that resolving this dispute would have any impact on whether an anime fan would watch a fucking anime. Are you going to watch the next Dragon Ball if Vic's not in it? I mean, a few people won't, but most people will. And evidence in point, everybody, even people who hated it, still bought The Last of Us 2. Appellee offered evidence showing that other students not only discussed the accusations against appellant amongst one another, but also in their decision to attend UNT, as opposed to another university, would be impacted by the resolution of appellee's accusations. Additionally, the appellant's own statements established her level of fame to the extent that she had earned awards, was well known, and was recognized even outside of the opera community. Now, those things are not true for Vic. He's not well recognized outside of the anime and Star Trek communities. He's just not. For example, this court noted in Lane the awards appellant had been awarded, which included an Oscar, contributed to establishing appellant as a public figure. In Lane, the trial court properly considered appellant to be a limited purpose public figure. Although Vic lost work as a voice actor and convention invitee, as a result of Funimation's tweets, there's no evidence that Vic's status in the general public is such that Funimation's tweets about him would actually impact the general public's decision of whether to attend an anime convention, watch a film, or buy an item of merchandise. And they could have. They could have done this, but they didn't. They could have provided all sorts of tweets saying, if you guys fire Vic, I'm not going to go. Or if you guys keep Vic, I'm not going to go. They could have tried to do that and they didn't do that. While Vic maintains that Funimation's tweets caused him to lose existing and future employment opportunities, that is an impact on Vic, not the general public. Because the evidence is lacking, unlike the appellant in Lane, Vic is not public, there's supposed to be an A there, not public figure or limited purpose public figure. The trial court therefore erred in requiring Vic to establish actual malice in support of his defamation claim. I think it's a good argument. I'm pessimistic about it, but I think it's a good argument. I think they've done what they can with the issue. And that's the ultimate problem. Are Vic's statements going to come back on him? They very well may. Never apologize. Don't do it. Funimation's published tweets are reasonably construed as an accusation of sexual misconduct against Vic. Yes. Yes, they are. Absolutely. Of course they are. Candorous Ordo. Hey, man, thank you so much for donating tonight. Says, I will admit to watching the next Broly because I grew up with Johnny Young Bosch and Power Rangers and Bleach, but I still stand with Vic and would love to see him replace Johnny Young Bosch as Broly. Of course. And there's nothing wrong with that. There's nothing wrong. Like Funimation recorded a different Broly for, Fighter Z or whatever, I think that's been established. And there's nothing wrong with that. You can like everything about a production and be still mad at a particular decision that they made, and you can still entertain yourself. That's up to you. Like, I will probably try Diablo 4, even though I still am pissed off at Blizzard. But I probably will. But I haven't played... Interestingly, I haven't played Diablo 3 since, which doesn't hurt Blizzard in any financial way. But I just like, I'm like, I don't care. I don't care about Diablo 3. Even though I kind of do. But I don't have as much. Never mind. Talking too much. Heresy! Felipe Mube says, duh, Dragon Ball Animator is named Akira Kurosawa. Yeah. If I see Monica in a hair salon, I'd be fat struck, not starstruck. With Vic would be gay struck. Only if he was wearing pants. Siren Jag says, rumor has it that Dunford has reached out to Preston Poulter for a butter recommendation, as friction when he's getting pegged by Leroy is causing his internal temperature to hit 165 degrees and making that red thing pop out and say that he's done. Oh! Siren! Did you just combine... Did you just make a turkey thermometer into a prolapse joke? I hate the internet. Oh my God. Okay. Back to the document. Funimation argues incorrectly that it did not state or imply in any of its tweets that Vic had engaged in any harassment or intimidation, sexual or otherwise. Which, as I believe I hammered in Funimation's brief, that is a fact question. That's a fact question. The publication of the tweet in and of itself is a fact question. The intent behind the publication is a fact question. Of course it is. Of course it's a fact question. And this is the big problem. This is the big problem that we've got. They're attempting to state that there are no fact questions that were not resolved in Vic's favor. And this is a big one. Because the judge agrees with them. In essence, he has to. He says there was no evidence presented on Funimation's part at all for any stage of it. That's something, let me give a general criticism of the documents. And it's only coming to me now as I think about it. The judge's opinion, the written opinion, stated that Vic failed to provide any evidence of any element. Any evidence of any element of any claim. And I don't know how much you want to hammer on the lower court judge's writing or decision making, but he says, so again, the judge asserts basically that there's no evidence that they published a statement about Vic at all, which is absolutely wrong. So, you know, whether, I don't know how much you hit on that, but it's there. It's there. Anyway, considering the substance of tweets leading up to those published by Funimation, Funimation statements can only be rationally inferred by members of the general public that Vic committed sexual assault and sexual harassment. Of course. Of course. Funimation's tweet states that it is an update on the, quote, Vic Mignogna situation. Funimation's own evidence shows that Vic Mignogna's situation refers to the accusations of sexual assault and sexual harassment against Vic, and also encompasses Funimation's, quote, investigation into those accusations. Should be an S there. Accusations. Funimation's tweet states that its decision to exclude Vic from future productions was following an investigation. The only rational inference from Funimation's statement is that Funimation investigated the sexual assault allegations against Vic and determined them to be credible. The fact is, Funimation conceded that its exclusions of Vic from future Funimation productions resulted from its investigation into tweets accusing Vic of sexual misconduct. And that's true. Of course they did. They're trying to have both. They're trying to have both. And you can't have it two ways unless you're on the internet. Funimation's first tweet could reasonably be read as confirmation of sexual misconduct accusations against Vic. Funimation's second tweet confirms. Now, the rational inference thing. Let me be clear on this. I think the prima facie standard is articulated as follows: the minimum quantum of evidence necessary to provide a rational inference for an element of the case. For each particular element of the case. So, a rational inference is drawn with a minimum, not the only rational inference, and that's what they're saying. They're saying the only rational inference, which I agree with, but it's really any rational inference. And that's something that was stated over and over at the trial court, and Judge Chupp decided to try and make a game and a joke out of it. But you want to know why Judge Chupp was making a joke out of the rational inference line? Judge Chupp did not understand the elements of defamation at the hearing. He had to look them up in the hearing. Which is weird. It's weird to think this, but the judge actually did not understand that is the legal definition of a prima facie showing in Texas. The minimum quantum of evidence necessary to support a rational inference of an element of the particular claim. That's it. And it's okay for a judge to not understand that. That's why you rely on the pleadings of the parties. That's why a judge at oral argument sits there and goes, okay, tell me what's the legal standard here? Does anybody have a legal citation? One of my first cases. Story time. One of my first cases was a case. It was family law in Minnesota. I don't do family law. I hate it. But I was just starting out, and I took on a case for a friend's family member. And we had gone to mediation. Okay, it was a custody issue. Gone to mediation. We'd done a full day of mediation. 6 hours was all the two parties could take. They, at this point, hated each other. And the other side was particularly nasty with statements at mediation. All right. But we dealt with 6 hours of mediation. We came back and we signed a document that said we've resolved these issues and we have these issues outstanding. Okay, so we remembered that we had reached resolution on the majority of issues, the overwhelming majority of issues. But the issue we had tabled for the very end was back child support, because the dad had been gone for 8 months and he owed, under Minnesota law, he owed his amount of statutory child support going back for those 8 months. He had zero say in the child's life for 8 months, which means he owed the full amount based on income, simple income analysis, really easy to figure out. So we knew exactly how much he owed under the statute. And that was tabled so that we didn't get bogged down in discussing this amount. And we had planned to negotiate down from the amount, because my client was thinking we can just figure out all this parenting time shit and then we'll get done. And the back child support, we'll negotiate that down. So we come back the next day, we resolve the other issue, and then we get to the back child support issue. Now we've already negotiated the amount of child support, and it's lower than the statutory amount because my client didn't need it. Frankly, my client said, I would rather have peace with this other person. I'm not here to fleece him out of this amount. So my client was willing to accept what lower than the statutory amount of child support. And so we get to the issue of back child support, and it was something like $6,800, right? And I said, okay, we've been in mediation a long time. We're going to put out an offer, and it's reasonable. And here we go. We don't really want to negotiate on this price. We think this is fair. $4,500. Now that's like a $2,300 haircut from what my client was legally owed. Like if we went to court, we would definitely win without issue on this, because it's flatly in the statute. Okay. And they said, no, we're not paying anything. Like, why are you doing this? You're going to pay something. And no, we're not paying a single dime of back child support. They said, okay, the whole agreement's null and void. And we left and we went to the hearing. At the hearing, they tried to present our statement that we had resolved these other issues as individual contractual agreements on those issues. All right? I know this is getting off into the weeds, but bear with me. I'm drinking. And it's like, that's not how that works. The parenting agreement is a full agreement in and of itself, and the concessions made in one area are impacting other areas. If they don't want to have concessions on these issues that we've worked out, then we can't take all the concessions we made here in an attempt to get back child support that my client needs over here. And the other attorney was like, no, that's not how it works. You can enforce partial agreements. And obviously you can't do that because it's unfair to people. So, but I wasn't actually prepared for that attorney to make that stupid argument. And the attorney didn't submit a brief, just came in and said, well, you agreed to these things. I was, no, we didn't. We don't have a parenting time agreement. We don't have a parenting agreement of any sort signed or anything. And so we're sitting there arguing this, and the judge yells at us, and she's like, "What's the law? What's the law here?" Like, I don't know. I was in no way prepared for this argument. It's one of the first hearings I ever did. Like, I don't know what the citation is, judge. I just know that I'm right. And so the judge actually left the statement and left the courtroom and had to go research because they didn't know either. And the reason they didn't know, this is a 30-year attorney opposed to me. The reason they didn't know is because they were fucking wrong. And so the judge came back and looked it up. And of course I was right. It was just an element of contract. But I want to point out the judges often don't know the law that's in front of them. They have no idea. Problem was not Chup not knowing the elements of defamation. The problem was that Chup decided to make a snarky comment and incorporate his lack of knowledge into the ruling. And that's one of the issues that they're trying to overcome here. And that's frankly a really hard issue to overcome. You had a judge who misapplied the law, but did it in such a way that he didn't write it down. He didn't write down his misapplication of law. He just said he concluded it. So it leaves a lot of leeway for you to argue it in the court, but it doesn't leave you much to argue against. And that's some bullshit. That's why Chup sucks. Sorry. It was way off. Way off topic. Long tangential story. Don't have time. Back to it. Judge Judy's terrible. She's funny. Terrible. Okay. Funimation's second tweet confirms this interpretation via its language regarding harassment and threatening behavior. And now Funimation can and does disagree with this. Unfortunately, according to the law, they don't get to at this stage. They get to at the next stage. And this is another point where fuck chupped up. Chup fucked up. No, I like it better. Where fuck chupped up. He chupped up when he didn't weigh the facts in favor of the non-moving party. Okay? And that is absurdly important. It is the law, and this is where hopefully the appeals court will be drawn to that attention. And that's a place where oral argument comes in to really focus, where you get a chance to potentially attempt to focus the court on this. Look, judges, your honors, Judge Chup improperly weighed facts in favor of the defendants that were disputed, and the evidence of the dispute of those facts is rife throughout their briefing. He cannot rule on this based on weighing this in favor of them. And that's really an ultimate aspect of this case that is coming through in this brief. And I think it comes through a little stronger in some of the other briefs as well. But that's where in oral argument, you have an opportunity to focus these judges on that point. Remember, all judges are ADD or ridiculous. Treat them as the dumbest lawyer in the room. They're not always the dumbest lawyer in the room, but treat them that way. And you focus them where you need them. And in this case, in my opinion, they need them focused on the idea that Vic was supposed to get the benefit of the doubt on all factual allegations that are uncontroverted and controverted. And he didn't get it on all of the crucial ones. Funimation concedes this interpretation of the first tweet by saying that the second tweet was, quote, in response to the continued heated back and forth between anime fans about Vic Mignogna. However, even if this claim were true, Funimation failed to make it clear that the second tweet was not a reference to Vic. A reader could easily infer that harassment and threatening behavior referred to Vic's behavior uncovered in Funimation's investigation. In short, Funimation's second tweet both confirms the meaning of the first tweet and accuses Vic of sexual misconduct a second time. The rational inference from Funimation's tweet is that both statements are statements accusing Vic of sexual assault and sexual harassment. I agree. And that's where you really want to hit hard on oral argument to point them to this. The trial court deferred to the factual assessments of the defendants in all of these cases, making making the judgment flat out incorrect. And this is something that's an interesting sort of point. We haven't really talked about much on the show, but oh, Charles Jones, by the way, thank you for the big donation. I really appreciate that. We haven't talked about that much on the show, but appeals courts are very different than district courts because appeals courts' decisions make law. They make law. So, when the appeals court renders its decision, it's considering the impact of its decision on every subsequent decision going forward. And that's a heavy burden for them to have. One of the ways they can have a minimum impact going forward is to determine that either the trial court just screwed up on an area of law that is already clear, like the factual benefits of the doubts being weighed in favor of the plaintiff, which is required. It's part of how the process for TCPA works. And for summary judgment, it's not like a new special TCPA thing. It's any dispositive motion. The non-moving party gets the benefit of the fact statements. If they can determine that the judge misapplied the existing law, and they can skip all of the other arguments that could make substantive law. Does that make sense to you guys? So there's this argument that's coming up here is the second amended petition. The judges have to be careful with this second amended petition argument because how they rule on this second amended petition can be used in the next case that comes before it where someone says, I'll either amend a petition, or someone says, wait, you can't amend a petition at that point. This would be cited as precedential if they reach a substantive conclusion on this issue, but they don't have to. And that's another maybe tactic at oral argument, is to direct the judges to a conclusion that provides the least long-lasting legal impact, the least new law being created by their decision. Is to simply say, look, chopped up. And thinking about it, if they rule against Vic on this second amended petition, then they're essentially making law. For or against Vic on the second amended petition, they're making law about the timing of the second amended petition. They're going to do that in ruling for or against Vic, unless they find some thing in the record to allow them to weasel out of it. And, I can think of a few things, but it's not the most obvious way to do it. So they can refuse to deal with the second amended petition at all and just send it back based on the factual errors alone. So that's something that I have a feeling they're considering that. Okay. So, part C. Sorry, and we'll try and get through the rest of this really quickly so we can get to that watch party. Even if the trial court did not err by refusing to consider Vic's second amended petition and its attachments, sufficient evidence was properly before the trial court to support each of Vic's claims. Ooh, that's not actually what I was thinking it was. Great. Vic reinforces his position that the trial court erred in refusing to consider his second amended petition and the exhibits. Okay, so they're saying this was sufficiently briefed in the initial brief. However, sufficient evidence was presented to the trial court to support each of Vic's claims because Funimation's motion to dismiss under TCPA included attached exhibits that established the elements for each of Vic's causes of action. Here's another way the court could go about not making law, is say, yeah, inside the TCPA, pleadings and motion documents and exhibits are allowed as admissible evidence. Therefore, we find enough admissible evidence to move past TCPA in the defendant's own filings to not even consider whether the plaintiff made a sufficient showing, or whether we need to consider the second amended petition, or whether we need to address the evidence that was not stricken or was stricken, or any of that. They don't have to address any of the issues on timeliness. They don't have to address any of the issues on objections. if they just determine that, one, the factual issues, and two, that there could be enough evidence in the defendant's filings to go ahead and support the prima facie showing. Funimation misstates the scope of evidence before the trial court in its motion to dismiss under TCPA by failing to acknowledge that the trial court considered the exhibits attached to the motion itself. The trial court also considered evidence offered by Rial, Toye, and Markey in connection with their TCPA motions. Such evidence also clearly and specifically established each of the elements for each of Vic's causes of action. The trial court held a single hearing for all of Appellee's TCPA motions to be heard together. The trial court granted each of the motions in a single order. The record does not reflect that any evidence admitted was limited to any particular purpose or party. And this is what the defendants wanted. And I will contend from the outset that a proper defense of each of the defendants would have been separate from the other defendants. They chose to defend together, and it has worked out for them. But I think the legally proper avenue would be to separate each of the others and to frankly throw them under the bus. But that's me. I'm a dick. What do you want me to say, Ty, you old boomer? I ran a marathon in 14 hours and 56 seconds after I died on the asphalt and had to be brought back. Sufficient evidence, number one, sufficient evidence was before the trial court to support Vic Mignogna's claim for defamation. Due to Funimation's failure to prove that he is a public figure or limited purpose public figure, Vic is a private figure. Therefore, to defeat Funimation's TCPA motion, Vic was only required to show clear and specific evidence that Funimation acted with negligence in publishing its tweets. Texas courts have defined, I hope they make the actual malice argument, and I think they will, but I hope they do. Texas courts have defined negligence in the defamation context as the failure to investigate the truth or falsity of a statement before publication and the failure to act as a reasonably prudent person. Sufficient evidence was admitted by the trial court to make that showing. Considering only the evidence offered in Funimation's motion to dismiss, trial court had Vic's tweet in which he specifically denies the allegations of sexual harassment and sexual assault that were the basis for Funimation's tweet. The affidavit of Tammy Denbo details the scope of Funimation's investigation into the accusations against Vic. Funimation's investigation merely included a review of unsupported internet posts, many of which were made anonymously and often just repeating the allegations made by parties in the case, discussions with Rial, who injected herself into the investigation, discussion with two anonymous fans, which we now know are most likely the Yost twins, and a single phone call with Vic. Importantly, none of those discussions involved Sarah Breckmeyer, whatever her name is, who doesn't appear to have actually made a complaint against Vic and got roped into this by Monica Rial's gravity. All right. Funimation does not include the content of the conversations, but concludes that the allegations against Vic are, quote, credible. Since Funimation reviewed tweets accusing Vic of sexual assault and sexual harassment and permitted Rial to inject herself into the investigation, Funimation knew that Rial claimed that there were, quote, hundreds of victims of Vic's alleged abuse and that Vic would be facing criminal charges. Funimation's silence on the absence of these witnesses and criminal charges is deafening. More importantly, such failure to explain the glaring lack of evidence, the lack of criminal charges, demonstrates a fact issue that Funimation did not act as a reasonably prudent person would in conducting its investigation, and that its publishing, publishing of two tweets accusing Vic of sexual misconduct are defamation per se. Even if Vic is properly considered a public figure, oh, this is what I'm looking for, thank you. Sufficient evidence was before the trial court to support a finding that Funimation published its tweets with actual malice. Actual malice is shown where there is a reckless disregard of the truth. Funimation provided no evidence that explains how it decided that the accusations against Vic were more credible than Vic's denials of said accusations. And I think that's important. I think that's important there. It is, they decided they were credible. What does that mean? That's completely subjective. And so therefore, let me put this out there. By saying it's credible, they're not saying it's truthful. They're trying to walk this fine line between the definition of credibility and truthful. So they can find the accusations to be credible. But the implication is that the implication by their statement is that the accusations are truthful. It's a very different thing. They're saying they're true. That's the defamatory thing. They didn't say, what is on my camera? They didn't say to the public that these are we found these accusations credible. By not saying that, they left the public with the impression that they were truthful. Because they said that they did an investigation. They claimed the investigation. No one else claimed an investigation. I mean, Ron and Monica did. Despite the fact that they were told not to, they did. But, that's a different question. And even in Turner versus KTRK Television, where the appellee was mistaken in its belief that court records supported its contention that appellant was involved in an insurance scam, the appellee provided sufficient evidence that the appellee could argue supported a good faith basis for the appellee's assertion. Tammy Denbo's affidavit, coupled with the tweets introduced into evidence, show that Funimation made no effort to determine whether it had any basis for the truthfulness of the accusations against Vic. In fact, that's one of the interesting things. I think Karen Mika shirks the responsibility entirely and just blames Tammy Denbo. Let's see. And Funimation is certainly not entitled to a presumption that it had any basis for the truthfulness of the accusations against Vic. Of course not. No, they're presuming they're the ones claiming they did an investigation. And that claim carries with it the weight of a multi-million-dollar corporation, presumably with a functional HR department and a mechanism for investigations. The evidence does show that Funimation had some motivation to respond to Rial, Toye, and Marky's tweets, which repeatedly and vocally attacked Vic and called on Funimation to investigate. By publishing its false tweets, Funimation published its tweets without any regard for truthfulness of the content. Worse, Funimation amplified Rial, Toye, and Marky's false accusations to a much broader audience due to Funimation's status in the industry, and also claimed to have investigated and found evidence to support the false accusations. Funimation gave baseless accusations from Rial, Toye, and Marky the appearance of credibility. Funimation's evidence in its motion to dismiss shows that Vic was damaged by Funimation's tweets. Funimation argues, so this is another element of the defamation. Even though this is defamation per se really is, did you publish the defamatory tweet? Because other than that, if it's defamatory and you published it, then damages are presumed, and the court is supposed to do that. Again, that's another thing that Chup just ignores. These are allegations of sexual misconduct from Ron, from Funimation, from Jamie Markey, from Monica Rial. They're all per se defamatory allegations. All of them should automatically pass most of the defamation tests once you establish that they were in fact published and about Vic. Once you do that, that should carry you through, because the per se defamatory nature presumes damage. And I think it presumes, if it doesn't presume falsity, it should. Okay. Funimation's evidence in its motion to dismiss shows that although Vic maintains he was not required to show actual damages, because Funimation's tweets can constitute defamation per se, the trial court was presented with evidence of actual damages. Specifically, Funimation offered evidence. This is in Funimation's brief. And by the way, it's also in Marky's and Monica and Ron's, because they're dicks. They're dicks. At the end of the day, they're dicks. And they're trying to fuck Vic desperately. They're trying to find that fertile lotus plant that is Vic and just plow it into oblivion in all of their briefing. And in doing so, they wanted to gloat that he was canceled by these conventions, that he was canceled from these shows. So they provided evidence of the damages. Again, Funimation fails to acknowledge to this court that Funimation presented evidence supporting Vic's claims in support of its motion to dismiss, and accusations of sexual misconduct or defamation per se, in which damages are presumed. So that's how the trial court will handle that, or the appeals court will handle that, remains to be seen. But it is a point that needs to be made, and it is a point that was not properly dealt with in favor of Vic. Nyx Hex says, sing in lemon voice. Take time with a wounded lung, 'cause it likes to wheeze. Take time with a wounded lung, 'cause it likes to wheeze. I like to squeeze. I've half the lungs I used to have. Ah! All right, number 2. Sufficient evidence was before the trial court to support Vic's claim for tortious interference with existing and prospective business relations. Notice how short this section is. Again, I addressed this earlier. Funimation again fails to acknowledge its own evidence in arguing that Vic failed to show evidence of tortious interference with existing and prospective business relations. Funimation's own exhibits show that Vic lost contracts with prospective, not perspective. Damn it! It's correct up here. It's wrong here. Now we've lost. Oh no! Perspective business due to Funimation's false tweets. Specifically, Funimation introduced evidence that all of Vic's 2019 convention appearances were canceled, and that the reason for those cancellations was Funimation's tweets. Good job, Funimation. This section, again, if you had unlimited time and word count, and this may come up at oral argument, it may not. If you have unlimited time and word count, you want to hammer on the idea that tortious interference with business prospects, prospective business relations, however you want to say it, that is something where you have to show that they knew of the possibility of engaging in relations with business. And it'd be good just to reinforce that Funimation actually has several contacts in the convention community and is a source for providing voice actors to conventions and has contractual control, in theory, even if not in practice, over their over the attendance of a voice actor at a convention. And therefore, it is Funimation's business to know whether or not Vic is going to be attending these conventions. And then they know that their statements will have an impact on his ability to attend said conventions. That would be something you'd add in and really flesh out legally. But I don't think this is still a weak section of the case in general outside of the vicarious liability. So that's how you could flesh that out. I don't know that it needs to be done. In all honesty, there are many more important things to focus word count on. So sufficient evidence was before the trial court to support Vic Mignogna's claim or theory, need to pick one. Well, that's a weird section. Now listen here, appellate court. You need to pick whether this is a claim or a theory. Damn it, Ty! Of vicarious liability. Vic Mignogna's claim for vicarious liability in connection with tweets by apparently they picked claim. By the way, subheadings are not really going to matter in the end of the day, but yeah. it's the substance of the thing. They apparently pick claim. I wonder if they'll say theory somewhere else. We'll see. Vic Mignogna's claim for vicarious liability in connection with tweets by Rial and Markey is supported by evidence of control exercised by Funimation as to Rial and Markey's decision to publish certain tweets and the statements contained therein. Funimation's argument against vicarious liability is based on a denial of its control over Rial's tweets. Funimation's analysis fails to give proper consideration to the specific facts and inferences supported by evidence of communications between Rial and Funimation regarding Rial's tweets accusing Vic of sexual misconduct. Funimation generalizes Rial's email to Lisa Gibson as asking for advice. No, this is a fact question. Just asking for permission. In fact, the specific statements made by Rial in her email are sufficient to support a finding that Funimation exercised control over Rial's tweets, such that Funimation can be vicariously liable for Rial's tweets. I agree. She wasn't asking for advice. She was asking for permission. What can I say? What can I do here? Rial's email to Lisa Gibson not only states that Rial doesn't know what to say when people ask about Funimation's investigation into accusations against Vic, she specifically adds, I don't know what I can say. I would have bolded the can or capitalized it or something. I would have done something to draw the court's. You're not really supposed to do that, but or italicize it. Do it anyway, which implies that Funimation has some authority over her statements. Rial continues, Funimation may be and then you just add emphasis added or something. Rial continues, quote, Funimation may be waiting to make a statement until Dragon Ball Super Broly has finished its run, or may, quote, not want to make a statement at all. This supports a rational inference that Funimation controlled whether Rial's published tweets on the topic, the content of the tweet, and the timing of the tweet. The overriding determination of, quote, if, what, and when Rial tweeted about Vic was Funimation's desire not to impair Dragon Ball Super Broly's performance or profitability. Accordingly, the trial court erred in dismissing Vic's claim against Funimation based on vicarious liability. And I think that's true. Funimation and all of the voice actors, who, by the way, have been told specifically by Funimation not to do certain tweets, that they cannot do certain tweets because they could jeopardize contracts and other business affairs of Funimation. They've been told that in the past. They know that an errant tweet could get them in trouble. Of course, Funimation controls their tweet. Sufficient evidence was before the trial court to support Vic's claim for civil conspiracy. We're almost done here. Funimation's argument that the trial court properly dismissed Vic's claim for civil conspiracy is predicated on the assumption that Vic's underlying claims were properly dismissed. As detailed above, the trial court was presented with sufficient evidence to allow Vic to defeat Funimation's TCPA motion as to each of Vic's underlying claims. Vic's claims were improperly dismissed by the trial court, which was presented with sufficient evidence of both the underlying torts and a meeting of the minds between Funimation and Rial. As shown above, Rial's email to Lisa Gibson asked for instructions from Funimation as to whether Rial could publish a tweet, what the tweet could say, and when it could be published. Additionally, the trial court was presented with evidence supporting a rational inference that Rial's tweet was actually published following receipt of instructions from Funimation. The concert of effort between Rial and Funimation is enough to support a rational inference that Rial and Funimation had a common goal and meeting of the minds on the object and course of action. I think the other thing that may have been left out here, and I might be misremembering this, so forgive me if I am, but I believe the trial court was also presented with evidence that Monica Rial pushed Funimation to make a statement. They hint at it up here in this thing. I thought it was stronger worded somewhere that you need to make a statement or whatever. I would have included this again and said that this also, and again, unlimited word count and all that, word count notwithstanding, that this also sets up the idea that that Rial and Funimation were acting in concert on Funimation's statement specifically. The Funimation was working along with Rial. In fact, she said, when are you guys going to address this publicly? I can't remember if it was that email or if there were tweets about it. I think there were tweets from Monica Rial. When are you going to issue a statement about it? Something like that, a day or two before they actually posted. I think that could have been included here. Personally. And again, I'm being very nitpicky on this stuff and adding in stuff with the benefit of not being the one who has to draft it, right? Always something to remember. Dan Carlin said something the other day. I was listening to the newest Supernova in the East. And this is something to really, really keep in mind as you read these documents. He was talking about World War II, and he says, if you went around... Wait, here, let me do my Dan Carlin voice. If you went around and you asked all of the World War II generals, titans of military conduct, how they would conduct a world war, well, you'd get several different answers, wouldn't you? Because there are different ways to fight a war. That's yeah, and that's a good point. So as you're doing this, if you asked a bunch of different attorneys how to approach this case, you're gonna get different opinions. You're gonna get different opinions on how to approach the appeals. You're gonna have different opinions on all of this stuff because there are different ways to go about it. This is the way that they chose. So, let's see. The trial court committed reversible error in awarding Funimation its attorney's fees and expenses. This is a throwaway argument at the very end stating, of course, yeah, Funimation's argument supporting its award of attorney's fees is predicated on a conclusion that the trial court properly dismissed each of Vic's underlying claims. Because the trial court's dismissal of each of Vic's underlying claims was an error, trial court's attorney's fee award must be vacated. Further, even if the trial court's dismissal was proper as to some cause of action against Funimation but not others, trial court's award of attorney's fees must be vacated because Funimation's fees were not segregated, and Funimation cannot recover attorney's fees for a cause of action that was improperly dismissed. Vic respectfully re-urges its appellate points and urges this honorable court to award the relief sought in the appellate's brief. So there you go. That's that. We've got a word count in the certificate of compliance. This is a, overall, I think this is a pretty good brief. There are minor errors in it. I know some of the other briefs, I think in particular Marky's has significantly more errors in it. We can only guess as to why. Probably has to do with order of operations, you know, when each brief was finished. The errors that are in this brief are pretty minor, and if they rise to any sort of level, they're at the level where they're remediable by a mere removal of what? This? Remove that sir from the sir reply. If the court takes issue with it, just remove those 4 characters and you've solved it. Remove a couple of apostrophes or whatever, and you've really dealt with all of the major issues in this brief. It looks like the theory of this is based on the idea, and I think we're going to see this in the other briefs too, giving the appeals court the easiest avenue to overturn Chup's decision. Remember what they're asking. Remember what they're asking the appeals court to do. They're asking them to undo Judge Chup's decision. They're asking them to overturn a fellow judge. Still a big thing. You're gonna look at someone else's professional work and say, I undo that. And a uniquely qualified person, right? Judges are held in a regard of making good decisions. Now, appeals courts do this every day. Every day, appeals courts are out there overturning decisions. That's not the biggest thing in the world on a grand scheme of things, but on an individual level. These 3 courts have to go, did this judge mess up enough to interfere with justice? And if he did, we got to overturn it. So that's the ultimate question. Did they provide a good enough case to do that? I think what they're doing here is providing the easiest way for the appeals court to do that, considering both Judge Chup and considering law going forward. And that's the thing that I think is really important in all of this. It's how this decision that they make will impact everything else. And for what it's worth, Beard and Harris and Martinez Sue have provided a way for the appeals courts to overturn Judge Chupp's decision without having significant impact on the underlying law. Anything else that they do will have a precedental impact on the underlying law. Because if they find that Vic didn't do good enough, they have to simultaneously find that his second amended petition could not be included, and that all of the reasons given in the motions to strike evidence were correct. And that will all be laid out. And they run the risk, if they don't address it individually, of supporting the idea that Judge Chupp's ruling on a public figure was how many people show up in a courtroom. Which leads to the conclusion that if you need someone to be a public figure, you just hire 30 people to show up in a courtroom. And imagine how damaging that is. And again, that's maybe something for oral argument. But that's that. Blaine20 says, "You scuck." Just saying. I think he means suck, but he's got a typo in there. But that's what we've got, folks. There's a document. I hope it's enlightening to you. Let me know in the comments how you feel about the document. Like I said, my thoughts on this one are pretty good. Pretty good. Working with word count is a tough thing. They've already got their briefs. I think they re-emphasize the most important parts of the argument, and I think they give the court an easy way to rule in their favor. That's all very important to do. Is it the right thing to do? We'll only know if they win. If they didn't win, it was presumably wrong. There's no other... That's how we determine these things. There's actual judges in this, so we'll find out. All right, guys, let's go ahead and read through the chats. And then tomorrow, we will be doing Jamie Markey's brief, which I believe is the one with the most issues in it. But like I said, I've only skimmed parts of the briefs, so I don't know that for sure. But based on what I'm reading, I think that's the one with the most issues. So maybe I'll come up with a drinking game. Like every time there's a typo, I'll take a sip of whiskey or something. Should be fun. Mercenary X says, "Nick, can you in the chat please do me a favor? Can you guys pray for my cat Houdini? Yesterday on Father's Day, my dad was drinking too much while I was working, and I think he got rid of my cat. Either toss him out or whatever, he's gone. My furball of 18 years. Aw, damn, that sucks, buddy. Sorry, man. I hope you find him." Malik Foxon says, "Hey, Rackets. Happy belated Father's Day, my guy." Hey, thanks, buddy. Verona Chan is paying me a visit and says she isn't leaving for maybe 2 weeks. She's even sleeping in the same bed. Fine, but it's awkward when she almost cuts off airflow while I'm sleeping. Kind of rude. Did you get the Wu flu? Oh, damn. Malik Foxon says, "One ironically hilarious thing about having COVID is that I can now pull off a lemon impression probably better than you. Literally the first thing I thought when I noticed my voice going, long as I don't die from coughing, this is going to be hilarious. Record everything. Record everything. Like, record yourself making cereal in the morning. Like, I'm going to put this milk in my Frosted Flakes, you fuckers." Or whatever. Record it all. That'd be great. Reese1 says, sent me a link to the horror movie I have suggested to you. Not asking you to do a watch together. Please watch with Drex. Honestly, I suggest this movie often. Then they check out the trailer and can't watch it. The Loved Ones, huh? Okay, I'll check out The Loved Ones. I don't know. I'm probably not going to download the movie from the Dropbox because that would be maybe a problem, but I'll find a legal copy of it. How's that? Kermit the Frog says, I'm keep it real with you, 57th Prime Minister of Japan, Shinzo Abe. Ain't nothing gonna get that birth rate up. There you go. I don't know why Kermit said that and why Kermit is talking about birth rates in Japan, but he is. Crusader Saracen says, is the appeals court remanding the decision back to the lower courts just as bad as denying the appeal? So that means it just goes back to Judge Chupp. If it goes back, it goes back to Judge. Oh, I see what you're saying. No, I don't think so. I think that Judge Chupp doesn't know how to run a TCPA hearing, and I think he's never run one before. Mainly because my evidence of that, by the way, is Chupp has never ever been appealed on TCPA. And no matter which way you rule on TCPA, it almost always benefits you to appeal on it. So the fact that he's never had one appealed tells me he's never taken one to the hearing. They've always settled out pre-hearing. I don't think Chupp's going to have any trouble running an actual trial. In fact, he might be a good trial judge. I think it's and if he conducts the trial like he conducted the TCPA motion hearing, it'll actually be fine. That's how a trial is supposed to be conducted. That was a problem with it. It wasn't a TCPA hearing. It was more like a summary judgment or a trial hearing where you get to, you have to present evidence and call witnesses and really bring it to the front. But that's not what the TCPA hearing is supposed to be. Let's see. Crusader Saracen says, so if the appeals court or district court, if it's remanded back down, rules that Vic is a limited purpose public figure, in your opinion, has there been a sufficient argument for malice presented just in case to overcome that? I think they've done the best that they can. That's actually a problem with the public figure doctrine, is that actual malice it's really hard to prove actual malice at any stage of anything. How do you prove someone knowingly lied, right? Like, how do you prove that? It's tough. If they find him a limited purpose public figure, I believe they have made a prima facie showing that they actually lied. I don't know if they can go ahead and prove it. I really don't. It'll be based entirely on the credibility of the parties in front of the witnesses, in front of the jurors, I should say. Or something else in discovery. That's always, of course, the problem. Oh, hey, I could do this. Make me a little bigger. Or, you know, it depends on if they get to discovery. That's another problem. I hope they've presented a sufficient argument. I can't say that they did or not. It's Candorous Ordo says, so what you're saying is, someone could convince a judge that my mother was a public figure. She could get a liver because as much as she deserves one, that's effed up, man. I guess Nova Zero says, dear God, the templates I am dealing with, consultants are terrible at reports. I'd rather be dealing with conslutes. How are you, Nikki? I'm good. I'm very good. Shadows King 101 says, waifu Coomer's BTFO'd. Nova Zero, I'm great, actually. You know why I'm great? Because there are a few people who are very desperate for the attention of other e-celebs or whatever. And e-celebs are garbage people, self-included. But they're so desperate for them, and they're getting ignored hard enough that they're now coming here, and it's really embarrassing for them. I mean, for fuck's sake. Some nobody says, strap on, you figs, we're going in. David Edward says, hey, chat, on this day of my birth, you figs are helping me maintain my faith in humanity. Rackets, you're okay. Oh, thank you. If I get by with an okay, I'm happy about that. JS says, I swear to God, if I get one more Joe Biden ad. Look, always going to be one more ad on how to beat Joe Biden. Donald Trump. Joe Biden. Joe Biden. Romer MGTOW says, here's some money for the bacon chip food truck to take out the banana stand. I'm for it. I'm for it. Cody Byer says, yo, Nick, check your email when you can. Guy I told you about needs your legal help. He emailed you a little over a week ago, named Zachary/Girthquake. I will check it out. I feel like I saw that email, but maybe my brain's playing tricks. Carlos Portillo says, hey, Nick, just curious here. You hear about hear about Joe from the Angry Joe show. There's some crazy allegations. Sounds very similar to the Vic stuff. Yes, I have heard about it. There's a ton of YouTubers getting Me Too'd. There's a ton of everybody getting Me Too'd right now. Me Too is strong. Why? Why? Ask yourselves, what major national level event has taken away attention from women? What is it? What is it? Black Lives Matter. Black Lives Matter. So what did they do? Me Too is not getting enough attention, so they go to the ultimate clickbait. YouTubers and Twitch streamers. They go all after them as hard as they can because Me Too women don't like black people getting attention. Facts. I'm not, to quote Drexel, I'm telling you facts. Women in the Me Too movement are so desperate for attention that they will go full racist to get rid of the black people attention. It's great. Some nobody says, whoever keeps flubbing Ty's documents, fire him. Well, this document wasn't flubbed. You're going to have typos in every single legal filing. You're gonna have them. It's just the way the workflow works out, the time limits, the people involved, and the issues of import are not in proofreading, grammatical, and typographical errors. That's not the important issue. Issue is, are your citations right? Are your arguments on the law right? You focus on those. You spend the majority of your time on those. And if you eventually, you can proofread it a couple times, but if you leave a typo or two in there, it's just going to happen. All right. Cal Clay says, Nick, your Streamlabs blm.gif a lol or question mark? Also, hey, I have no idea what you're talking about. Streamlabs blm.gif? I have no idea what that is. I haven't done anything for Black Lives Matter. I don't believe in the organization of Black Lives Matter. Is Halson says, Sir reply, it's ma'am. JC Gaming says, I wonder if any of Ron's ex's favorite song is Hit Me Baby One More Time by Britney Spears. Oh no. Some nobody says, get your porky horsewoman to watch Ty Savage you, Ron. Ew. Some nobody says, nobody on earth has a fat camp wide enough for Marky. Jason the Great Awakening says, would Drexel call a fat camp a buffet? God, I miss buffets. Mario Carter 13 says, Druckmann effed himself, mocap pitcher and catcher. I've heard that rumor. I've heard them vehemently deny that rumor. I also saw a picture of of Druckmann in mocap. So I fully believe that that Druckmann fucked himself in mocap. Fully believe that. Let's see. Jason the Great Awakening sent me a pair. Thank you so much. DCV Titan says, if this passes appeals, doesn't it go back to Chup? Yes. If it does, what keeps him from just fucking the dog again? It's, again, I covered this a little bit ago, but it's the nature of the style of case. It's a big difference in how the case goes forward. The TCPA is a critical place where he made mistakes, in my opinion. There'd be less opportunities for him to do that and impact the case in such an amazing way in the forward, because you got like a jury. You've got a jury trial, and in that jury trial, you're not trying to convince Chup of something, you're trying to convince people. You also have the tools of discovery at your disposal. Jason the Great Awakening says, was Chup unduly influenced by Ron's bull pegging him for a favor? Gross. Gross. JC Gaming says, oh my God, supposedly there's now going to be a Twitch blackout this Wednesday because of the Me Too second wave. Are they serious? SMH. Wait. If it's a Me Too second wave, why would that be a blackout? If that's the case, I'll still be on Twitch. I don't care. Jonger Bongers, welcome to paralegal status. And then thank you for upgrading to lawyer status. Lee from Asia says, how broke will Ron be when he loses this? Look, if they lose a ton of money. They lose the money to their law firm, and then any damages that come out of it. Significant loss of income that they can't afford. I want to point out something, by the way. I've said this before, but I'll say it again. I was wrong when I said that filing a TCPA motion was like lighting $10,000 on fire and throwing it away. Ron, if we take his statements to be true, has confirmed that it's like lighting $50,000 on fire and throwing it away. Because Ron had to pay $50,000 out of pocket before his insurance kicked in, according to Ron. That's if Ron is to be believed, and that it's not actually significantly higher than that. All of this, all of it could have been avoided. All of it could have been avoided with settlement. It's Vic. All I had to really do was talk to him. They wouldn't do it. So I was way wrong. I said 10,000. It's actually 50 grand. But what a fucking dummy. Whew. Jason the Great Awakening says, Ron is clearly panty. They messed up casting with commies again. Jason the Great Awakening says, so which part of this whole epic saga, anything less than a paid Chinese assault to take the media as a whole? I don't know what that means. Gilbert Guy says, hi, Nick. Love the channel and the content. L'chaim. Hey, thanks, buddy. Thanks, buddy. I appreciate that very much. Kalinka Pavlova says, I see Siren Jag has become more degenerate. Hard to imagine, but it's true. DOG Beerus says, sing in lemon voice. I don't know what the tune of this song is. What is the tune of this song? Sometimes you've got to squeeze. Sometimes you've got to say please. Sometimes you've got to say, hey, I'm gonna fuck you softly. I'm gonna screw you gently. I'm gonna hump you sweetly. Gonna ball you discreetly. I don't know what the tune of that song is supposed to be. I apologize. Oh, is that a Tenacious D song? I don't listen to Tenacious D. But I believe you. I like them just fine. I just don't. It's not. I'm not familiar. Macca Jr. says, had to school some friends about Vic. They said, isn't he a rapist? Got so pissed, so now they know all the lies they did against him and are all supporting him now. Found out my child is going to be a girl. Oh, cool, man. Also, rip to you. Archangel Nishan says, Nick, I send you a DM to the media account if you want to look into it. Hey, thank you. Thank you very much. Keck7 Go says, Nick, read the Discord DM I sent you. Don't forget. Okay. Mario Carter 13 says, not showing work. That's why lawyers are bad at math. Orochi Taco says, can someone in the Discord make a video of The Last of Us 2 scene, but with Monica's face Photoshop pegging Ron? Hi. Bad Vibe says, Nick's nose has his own P.O. box. The problem is his nose resides in another zip code and why Nick has an Uber driver. Snarkdacon DM says, maybe an old joke, but real. Marky and Judge equals 2 girls, 1 chup. Dominus Sex Machina says, I know it's been a while, but here's $10 in Corona bucks to aid Vic and Ty's crusade against War Master Lemoyne and his Consluts Astartes. Thank you very much, Dominus. Bad Vibe says, are these briefs Fruit of the Loom or Victoria's Secrets? Fruit of the Loom. Fruit of the Loom. Lane 20 says, I hope you like honey. And I was trying for the same coolness of Fisk. Did you send that honey, Blaine? Because because I got some honey. It's upstairs. I haven't showed it on stream, but I did get some honey. I'll show it. Did you send me that? Yeah, Morty J says, people keep harping on increased COVID due to reopenings. I eagerly wait to see COVID numbers for the protest time frame to hear their BS excuse. Cemetery Lady says, a bunch of pro wrestlers have been Me Too'd within the last week too. Crazy, and I feel so bad for all these men. Problem is, you don't know. Like, that's the problem with Me Too, is you don't know. You don't want to feel bad for a rapist if they actually did it. But fuck that, the Ellis guy, whatever his name is, the comic guy. I was reading his accusation. It's literally just he flirted with women and tried to have sex with them. Adult women. Maybe I missed something. But when was it a problem for a guy to try and have sex with a woman when they're both adults? Like, and I was reading one of the things and it said, I know this is consenting adults, blah, 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 but we didn't consent to being manipulated. Yes, she fucking did. Warren Ellis. Yeah, that's his name. Maybe, and again, maybe I'm missing something from the Warren Ellis issue, but my God, if I was single, I'd be trying to have sex with women. Like, you got to take a shot, otherwise you're never gonna get anywhere. Like, you have to try. Anyway, weird. Onibushi Kabuto says, also Drexel, I'm gonna educate that ass. Mr. Schwagan says, Ron's a bruh. Keck7 Go says, DSP will be the king of the Twitch blackout. Hail DSP. Mr. Schwagan says, you might be right about Chup not experiencing a TCPA since it seemed he wanted them to settle through forced mediation. Thoughts on Discord picking censorship versus free speech? Terrible. It's terrible. You provide groups for people to, like a place for people to gather in groups and talk. Who cares what they say in those groups as long as it's not illegal, which is basically just child porn. Other than that, don't bother. No one important says, just wanting to know when Ronversations by Proxy will be this week. We're going to make fun of Jamie tomorrow because she's a terrible person who deserves it. Well, yes, of course we're going to make fun of Jamie. Ronversations by Proxy will not happen this week, most likely. It'll probably be next week or Saturday. We've got a full week of briefings and other things. It could be Friday if I'm not able to put together the Chad Dad show. But I think we're going to have a Chad Dad show on Friday. Esme Illis' anime says, sent a DM, have fun. Missed 7% all the time. Okay. Talonseer says, people in chat are saying that Chup lost his seat. He didn't lose his seat. He lost his bid for the appeals court. He was running for the Court of Appeals, and he lost that election. He didn't lose his existing seat. How does that affect court or the appeal decision? If Chup is unable to preside over the case, if he loses his current seat, it would just be appointed to a different judge. That's all. That's it. Angry Baneling says, Nick, hashtag waifu lives matter in these hard times. They do. Waifu lives do matter. Shane Malbuff says, Ron is wasting so much money that it could have all been used for a second stimulus check. There you go. All right, guys. When are you doing the Warhammer painting with Az Healed Babyface again? Will it be on this channel? It will be on his channel. That's what you asked. Will it be on his channel? Yes, it'll be on his channel. Noon Central Time on Wednesday. Shit. It means I gotta prime some models tomorrow. But noon Central Time on Heal versus Babyface will be the Warhammer painting stream. After that stream, I will hashtag transition into the live chat Wednesday, which may be a little late. I don't know how long we'll be on stream with Az, but I assume we're going to be talking Warhammer while we paint and stuff like that. So it'll be noon on Az's channel. And then normally Live Chat Wednesday is 2 p.m., but it'll be whenever Az's channel is done. I'll go to Live Chat Wednesday. And then we will have Sriracha on this channel that night. Wednesday's a very busy streaming day for me. So, also, yes, I would be remiss if I didn't shill the Discord, which you can currently get to by either being a super lawyer on YouTube or by contributing $5 or more on Patreon. The $5 level gets you into the Discord. The $10 level lets you participate by voice in Live Chat Wednesday. And the $20 level comes with some benefits that need to be probably revisited because they're not what they initially were. But those are available. You can check them out on Patreon, joining the Discord. It's a great little sub-community. It is relatively curated because of the paywall. It is not an open Discord, and open Discords are cancer that have also been raped. So the closed Discord is much, much better. And if you want to have access to a great community of good people, go ahead and join on Patreon. I would say New Project 2, but as far as I know, there's not an existing bank for New Project 2. And so I'm not suggesting people join up there right now until I get confirmation from Dick that something has changed. So there you go. That's what we've got for tonight, guys. So let me go ahead and start this outro. We're going to end relatively on time today, and then I'm going to go grab some snacks, and then we'll be on at sometime close to the start of the hour for the movie The Way of the Gun with Benicio del Toro, Ryan Felipe on twitch.tv/Rekieta Law. You have to have Amazon Prime to participate. All right, guys. Thanks for hanging out tonight. Hope you have a good night. Peace. Peace.
From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folk, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet,